Have Genesis Clark here, Joel Evans is present, Nikki Gimbel, Andrea, I'm going to mispronounce your last name, White, Carrie Vashi, Jenny Working, and Lee Ziegler. Kevin D'Antonio, the county attorney, is also present, and Kelvin Hugie, the BZA attorney, is also present. Because the hearing tonight is a public fact-finding meeting, we are in compliance with the Freedom of Information Act and SC Code 629-70. 15 days prior to this hearing, an announcement was printed in the Post and Courier, a sign was posted on or near the designated property, and a notice was mailed to the applicant or the applicant's representative to property owners within at least 300 feet of the property and to parties in interest. Persons, organizations, and the news media that have requested declaration of our meeting have also been notified. Board members, the meeting notes for the May 5th, 2025 public hearing were sent to you. Are there any changes? If not, may I have a motion to approve and a second?
I so move.
A motion by Mr. Truslow, a second by Mr. Seidel. All in favor, is there any discussion? No discussion. All in favor, please say aye and raise your right hand.
Aye.
All right. Our case rulings from this and any BZA meeting are available for public review and inspection during normal business hours at the Charleston County Zoning and Planning Department. The Board of Zoning Appeals is a quasi-judicial body that has final decision-making authority on 1, appeals of zoning-related administrative decisions. The BZA is authorized to hear and decide appeals only on zoning-related matters where it is alleged there is an error in an order, requirement, decision, or determination made by an administrative official in the administration or enforcement of any of the zoning-related regulations. A 2/3 vote of the quorum present is required to overturn the decision of the planning director in an appeal. A special exception is an exception issued by the BZA authorizing a particular use in a specified location within a zoning district upon demonstrating that such use complies with all conditions and standards specified by the Zoning and Land Development Regulation Ordinance, ZELDAR. The BZA must find that the special exception request meets all 6 of the approval criteria in the ordinance in order to grant the special exception. A simple majority is required to grant a special exception. A variance is a relaxation of the BZA of the dimensional regulations of the ordinance where such action will not be contrary to the public interest and where, owing to conditions peculiar to the property and not the results of actions or the situation of the applicant, a literal enforcement of this code would result in unnecessary and undue hardship. And such variance is consistent with Section 629-800 of the Code of Laws of South Carolina, Title 6, Chapter 29. The BZA must find that the variance request meets all 7 of the approval criteria in the ordinance in order to grant the variance. A simple majority is required to grant a variance. Our purpose tonight is for interested parties to be heard in order to assist the board in gathering evidence pertinent to each case. If the members of the BZA feel the need for further information to clarify a case, the board has the authority to subpoena witnesses. It must be understood that the rules of your neighborhood or subdivision are binding and that we can take no action that will negate their jurisdiction over your property. In addition to your testimony, our board has been presented written information submitted by the staff, by the applicant, or the applicant's agent for each case. This information is now considered to be evidence and is entered into the permanent record of this body. It is assumed that it is complete, true, and accurate. In addition, we have been presented data assembled by staff for the purpose of clarifying the location and the application's effect on surrounding property. Our board is empowered to approve with conditions, or deny a special exception or variance request. We are authorized to defer a case should there be the need for additional information. The BZA's final decision will be mailed within 10 working days of this public hearing. It will be mailed via certified mail to applicants and via U.S. mail to neighbor and community interest notice list. If an applicant's request is approved, the applicant should contact the Charleston County Zoning and Planning Department staff to discuss the next steps in the process. Variances and special exceptions granted this evening are valid for 12 months after this meeting, and a 1-year extension may be granted only if construction or development has commenced or has been diligently pursued. However, if an applicant's request is disapproved, and if the applicant wishes to appeal the decision of this board concerning the case, appeals must be addressed to the circuit court. SC Code 6-29-820 states that an appeal must be filed by the applicant within 30 days after the decision of the board is mailed to them. Failure to file an appeal within the time limit deprives the court of the jurisdiction to hear the matter. Because this is a quasi-judicial body, everything said in this meeting must be complete, true, and accurate. All of the information provided to the BZA is considered evidence, and the board may certify contempt of circuit court if false statements are made, either in writing or orally. Each person who wishes to address the board will be sworn in by the BZA secretary before they provide testimony or evidence. In order to expedite the procedure, those wishing to speak will please stand as a group, and Mrs. Working will administer the oath.
Please stand and raise your right hand. I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do. Thank you.
All right, thank you. I will now call each case by case number. Staff will present facts pertinent to the case and limited to 5 minutes. I will then call the applicant. The applicant will stand and state his or her name and current address for the record before presenting testimony pertinent to the case, limited to 5 minutes. I will then ask for all those speaking either in support or in opposition to the case, and they will follow the same procedure for identifying themselves and are limited to 2 minutes each. The applicant will then have a chance to reply to any opposition, limited to 2 minutes, and then the BZA will make a motion to close the case to the public. Finally, the BZA will make a motion concerning the application, stating specific findings of fact and conclusions of law. Tonight, we will hear 1 old business case and 6 new business cases and 6 new public hearing cases. Mr. Ziegler, can you please introduce the old business case BZA 0225000843?
Yes, I can. The applicant and property owner, Colin Gardner of Gardner & McCulloch LLC, represented by Kimberly Sayer and Justin Hetherington, are requesting a special exception to establish a short-term rental property, extended home rental in the low-density residential R4 zoning district at 2173 Welch Avenue, or TMS number 343-06-00-063 on James Island in Charleston County. The subject property and surrounding properties are located in the low-density residential R4 zoning district. The property is 0.16 acres and contains a single-family residence with 2 bedrooms that was constructed in 1950 per Charleston County records. The applicant would like to rent 2 bedrooms and will provide 4 parking spaces. The maximum number of guests allowed will be 4. The property is not owner-occupied, therefore the property is not eligible for a limited home rental. The BZA heard this case at the April 7th, 2025 BZA public hearing, where it was determined that additional information regarding the logistics of the rental arrangements between the 2 LLCs was necessary before rendering a decision. Mr. Truslow made a motion to defer the special exception application, and Mr. Neal seconded the motion. The motion passed unanimously. The applicant submitted a detailed letter of intent on April the 18th that gave staff clarity regarding the intent of this proposal. The applicant's letter of intent addendum states, after reviewing our original application and the meeting testimony, we acknowledge that there was an internal miscommunication regarding the intended use of this property. We would like to clarify that our intent is to use the home as a short-term rental when it is not being occupied for corporate housing purposes. The property will serve 2 distinct but complementary purposes. 1, corporate housing. When available, the property will be leased to Wolfline Construction Company to house its employees working temporarily in the Charleston area. These stays will be governed by a lease agreement between Wolfline Construction and McCulloch and Garner. The duration of these will typically be for 30 days or longer, thereby qualifying as long-term use, not regulated as a short-term rental. A local contact person will be designated and provided to the county as required. 2, short-term rental. When the property is not in use for corporate housing, we intend to offer it as a short-term rental for individual terms of 29 consecutive days or fewer for a fee. These rentals would comply fully with the county's short-term rental guidelines. The property will be advertised on public platforms such as Airbnb or VRBO. All short-term rental reservations will be handled directly and tracked internally. We will maintain accurate records of all short-term rental stays, including the number of rental days, rental parties, and any agreements, and will provide these to the zoning and planning director upon request, per county requirements. A local contact person will be designated and provided to the county as required. Here is the zoning map and the zoning ordinance requirements. This is the 300-foot radius map and a couple aerial photos. This is the subject property. We posted the property on March the 14th and May the 15th, 2025. And this is a couple pictures of the property showing the proposed parking in the asphalt and grass driveway. 2 parking spots will be in front of the gate, and the other 2 will be behind the gate. Here are a couple of the surrounding properties and Welch Avenue in both directions. This is the survey, site plan, tenant notice, and plat. And regarding the approval criteria, we stated that it may meet 1, 2, and 3. The Board of Zoning Appeals may approve with conditions, or deny the request based on the BZA's findings of facts unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the application, the board should consider the following conditions recommended by staff. 1, prior to zoning permit approval, the applicant shall complete the short-term rental property limited site plan review process. 2, the use shall comply with all requirements of Article 6.8. 3, this property shall not be used as a short-term rental for more than 144 days in aggregate during any calendar year. 4, the property owner shall be responsible for ensuring that tenants comply with the Charleston County noise ordinance. And we did receive 1 public comment in opposition to this application. Are there any questions?
Thank you, Mr. Ziegler. Mr. Neal?
Thank you, Mr. Chair. I remember this back in April, because I would remember doing the deferral or seconding the motion. I can't recall if we had any issues before that, or if this was the only issue, the legality of basically of using it for corporate housing versus a short term. And if we didn't, I'm sure we don't have to have the public hearing anymore, right? We've already had that, correct? Does it have to open back up?
At what point did we defer the case? Was the public hearing still open?
That's why kind of where my question is going.
I believe it was still open, and we did have some questions for the applicant to clarify, so we should give him an opportunity to come back up.
Okay, because the only thing I have is the parking. The site plan only shows 3 cars on it, and I'm sure it's just my lack of knowledge of being able to make sure we have 4 cars there. But I don't recall any other issues.
You can't really see it. It is shown on the site plan. It's just a rectangle box.
Okay.
It's not an image of a car like the other 3.
That's fine. So, because I don't remember any other issues, it was really just the legality of the housing and stuff like that. So I'll hold anything if there is a time for the applicant. Thank you, Mr. Chair.
Thank you. Any questions? Is the applicant present? If you would come forward, state your name and address for the record, and tell us why we should approve your request. For the second time.
My name is Justin Hetherington, 2908 Wilson Creek Lane, Johns Island, South Carolina, 29455. I apologize for the first go-around here. We was given some information that was not 100% correct, so our goal was not to 100% do our corporate housing, which I guess we went through with a little bit more information. We aren't required to go through that this process for the corporate housing, and then our goal is to Airbnb, obviously under the allocated time that we could on this, and that's our goal, our intent.
All right, thank you. Anything else? Board, do you have questions for the applicant? All right, well, thank you for your time this evening. Is there anyone else here to speak in favor of this application? Is there anyone here to speak in opposition to this application? All right, we will close the public hearing portion of this particular application, and I'll ask the board if they have any other questions of staff. All right, we're ready to roll tonight. That being the case, I would like to entertain a motion. Mr. Seidel.
Mr. Chairman, the latter case, BZA case 02. In the BZA case 02-25000843, I move that we approve this request for extended short-term rental. I find that it meets all of the conditions required for short-term rentals, that is compatible with existing uses in the vicinity and will not adversely affect the general welfare or character of the immediate vicinity, that adequate provision has been made to protect adjacent properties. There's adequate parking for parking places provided. There is fencing, landscaping. The applicant has arranged for trash pickup, and that it complies with all applicable rules, regulations, laws, and standards of the ordinance. And this is subject to the 4 conditions that were outlined by staff for approval.
Second.
Second.
Any discussion? All in favor, please raise your right hand, say aye.
Aye.
Motion carries unanimously. Heather, thank you so much for coming back tonight. Your application's been approved. Within 10 business days, you'll receive via certified mail a notification from staff and follow up then with the next steps. Thank you. All right. Our next case will be presented by Mrs. Workings, and it is case number BZA 0125000843.
Okay. The applicant, Sean Strobel of Strobel B&D Scrapyard, and the property owner, Donna Strobel, represented by Barry Whalen of HLA Inc. and Ross Appel of McCullough Khan Appel Esquire, are requesting a variance to waive the required 8-foot vehicular use perimeter buffer and to waive the required 40-foot type F land use buffer for an existing salvage yard at 1951 Stokes Avenue, which is TMS number 475-04-00006 in the north area of Charleston County. The 5.42 acre subject property is located in the industrial zoning district. It is bordered to the southeast by industrial zoning. The adjacent properties to the north are located in the low-density residential R4 zoning district. The adjacent properties to the east are located in Berkeley County and contain railroad tracks. And the adjacent property to the south is located in the city of North Charleston's jurisdiction. The planned development, PD 161, the Stokes Track parking property to the west, is the approved entrance to and parking lot for the subject property. The applicant is currently in the site plan review process, and this is the proposed site plan here. This is the zoning ordinance requirements. The 300-foot radius map, the aerial map. We posted the subject property on May 15th, 2025. Stokes Avenue. And again, the site plan, the landscape plan. This is an exhibit provided by the applicant, a site structure exhibit, and the plat. Regarding the approval criteria, we stated that the request meets 1, 2, and 3. It may meet 4, 6, and 7, and it meets 5. The board may approve approval conditions or deny the request based on the BZA's finding of fact unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the application, staff recommends the following condition. 1, prior to zoning permit approval, the applicant shall complete the site plan review process. Any questions?
Thank you, Mrs. Workings. Board, do we have question members for staff? No question for members of staff. All right. Well, is the applicant present? Mr. Appel, if you would please come forward, state your name and address for the record, and tell us why we should approve this application.
Yes, sir. Good evening, Mr. Chairman, members of the BZA. My name is Ross Appel. I'm with the law firm McCullough Khan Appel, and I'm over at 2036 E Wall Street over in Mount Pleasant. I am here today on behalf of Strobel B&D Scrapyard. I've got Mr. Sean Strobel here in the audience, as well as our technical professional who needs no introduction around here, Mr. Barry Whalen with HLA. And the purpose of our request today is to request 2 variances for the existing salvage yard located at 1951 Stokes Avenue. And specifically, we're requesting a variance to waive the 8-foot perimeter buffer that applies to all industrial properties, as well as a variance to eliminate the need for a 40-foot type F land use buffer adjacent to the residential properties in the area, several of which are actually owned by my client. As I mentioned, the property is zoned industrial, obviously the most intense industrial base zoning district the county has, and it's been operating as a scrapyard since 1984, which coincidentally is the year I was born. And the property has a very unique history. Prior to its use as a salvage yard, it was a landfill. And like many former landfills that are no longer in commission, it's been capped and sealed, and that really presents the core of our variance request today. Because when you're talking about establishing a landscape buffer, you're talking about turning dirt, you're talking about planting trees, and all of those activities, unfortunately, would disturb the existing landfill and create a host of problems, not just for my client, but for the neighboring residential properties. And so turning to the 7 variance criteria, it is very unique in this business. I've been before the BZA now many, many times over the years for the staff to acknowledge right up front that 4 of the criteria have been satisfied. Criteria 1, criteria 2, 3, and 5. These are actually the hardest criteria to satisfy when you're coming to the BZA. So unique and exceptional circumstances, that's the landfill history. Unreasonable restriction, the property cannot be developed and redeveloped but for the granting of this variance. My client's actually in the site plan review process. He's in the process of trying to improve the condition on his property. He's in the process of removing a lot of unpermitted structures in that buffer zone. And in order for him to continue advancing through the site plan review process that he has voluntarily started, we need this relief. So turning to the 3 items that need some further comment, detriment to the public good. Originally, the landfill operator to the south had raised some objections about the requested 8-foot vehicular perimeter buffer. We have since worked out an agreement with the neighbor. In fact, their counsel is here today. The bottom line of that agreement is we are agreeing not to do anything in that 8-foot buffer zone between our property and theirs. So we're not going to be encroaching into their property by sticking containers or, scrap material or other things that are on site. And it's my understanding that they're satisfied with that. They've withdrawn the objection, and we are fine with a condition, should the BZA be inclined to grant our variance, that we agree to that in writing and be bound by that as part of the variance approval today. The need is not self-created. The need for the variance is not self-created. My clients were not involved in the landfill business at all prior to 1984. And that, again, is the core of the hardship in this case. Finally, on the issue of conflicting with the comprehensive plan, this property is zoned industrial. Salvage yards are very important these days. I mean, this is a recycling business at the end of the day. And part of what my client does here is ensure that landfill waste is reduced and things of that nature. So we've got some technical exhibits here. Mr. Whalen is prepared to speak to. Happy to answer any questions. My client has also improved the condition of the border between his property and the residential areas. So even though we're not able to do a 40-foot landscape buffer, he's improved the vegetation in that area. He's eliminated some junk from that area, frankly, and done as much as he can do to be a good neighbor. The property is screened pretty well from the street already. We've got good exhibits to that effect in your packet. And we, again, would just respectfully request the BZA grant our 2 variances. We're happy to include the condition we negotiated with the landfill owner, and we're here to answer any questions that you may have. And as I mentioned, we've got our technical team here, as well as Mr. Strobel, that can get into the weeds on some of the more nitty-gritty specifics. I see my time is running out, so.
Well, thank you, Mr. Appel.
All right.
Let's see if we got questions up here. Mr. Neal will kick us off.
Thank you, Mr. Chair. Thank you, Mr. Appel. 2 quick questions. You mentioned one that go maybe the site plan or the TMS map plan would help. That your client owns a couple of the additional properties around it or something like that. So if you could point those out, hold on, that's the first question. Point those out, which ones they own, so we see that those aren't really affecting us if they're the same owner. And the second question is, the landscape buffer or the perimeter buffer that you're asking to be waived, which is fine. Buffers are also used for screening. If you can detail a little bit on what your screening methods or a fence or something like that, just on the one side that backs up to the residential, so we can understand that a little bit better. I'm sure you've already addressed it.
Certainly. So good question. So taking the first one, I see we've got the TMS numbers on the screen. My client owns the parcel ending in 026, which is zone PD. That is the current entryway to the property, and it had to get the PD zoning to facilitate sort of some unique configurations on that property. That area is actually very well screened. And my client also owns the property ending in TMS number 005 there to the south.
Okay, so we're really only talking about the top three, 049, 028, and 027.
That's correct. And then the landfill, the current landfill owner is the property to the southeast at 018. That's the property owner we've worked out that 8-foot agreement with. And to your second question, we have got some exhibits here today that we'd like to share with y'all. And this depicts...
I mean, I don't have to have them. I mean, if you just want to just briefly say what the screening is for those three residential properties, that would probably...
Sure.
what's
So
needed.
it's fencing, it's existing vegetation. We've got some before and after pictures here showing the condition of the shared property line with some of the residential properties. And as you can see, towards the left hand of the exhibit, the fence was in very deteriorated condition. The vegetation was in bad shape. There was frankly a lot of unsightly material on the shared property line. That has all been cleaned up, removed, and we're trying to do our best with providing a good buffer without, again, turning soil, breaking the cap of that landfill, and opening up a can of worms nobody wants to get into. And we've got handouts of this exhibit that various...
That's fine, Mr. Bell. So, Mr. Chair, if you'll, I'm just trying to make sure he summarizes basically the three properties I was concerned about that were not owned by either client or the landfill guys, 027, 028, and 049, and you're stating on the record that you're addressing those screening of those properties.
Yeah, we're doing the best we can with the tough and unique
that's fine.
exceptional
That's all I needed
circumstances.
to hear.
And client
Thank you,
wants
Mr.
to be
Chair.
a good neighbor.
All right, Mr. Jordan, did you have a question?
Yes, sir. So I know where this is. And I was appointed to this board by a minority member of county council from North Charleston, so I think he would want me to make sure those neighbors who are, it's a minority committee, are taken care of. So maybe you've answered a little bit what I was going to ask about some of the improvements, some of the cleanup, but then you said cleaned up some of the junk. Okay, well, what about all the junk that might be affected to the neighborhood?
So the whole reason, that's a good question. The whole reason that we are even in the site plan review process is because we are in an effort to clean up a lot of the property, to include a lot of the existing structures on the property. We actually have another exhibit along those lines to show which of the existing structures we're in the process of taking down. So if you look over here, there's existing container sheds that are located in this area that are close, relatively speaking, to the residential properties. These structures are going away as part of this whole process. These structures are currently located in not just the buffer, but also the setback. And you know, that is going to be a major net improvement, net positive for the community. We just spoke about the fencing and vegetation management, the existing vegetation along the shared property lines with the residential properties. We're committed to doing that. We're committed to being good neighbors. But the biggest thing here, the worst possible thing in the world for the neighboring residential community in this area is if we were forced to have to comply with the 40-foot buffer requirements, because what that would mean, I mean, we could do it, but it would cause an environmental disaster on the property. It would cause the landfill to be breached, and nobody wants that. So that's the reason we're here. That's the reason we're seeking this variance. But this whole entire effort that we are engaged with the county on is in the spirit of improving the condition on the site, making it more sightly, and preventing, frankly, an environmental problem by disturbing the capped landfill in place.
All right, let me ask you a follow-up question. I certainly know how scrapyards work, and I mean from the outside. You push your shopping cart there full of stuff, you sell it, you push the shopping cart in the ditch. People bring stuff to a scrapyard, what don't sell, throw it in the ditch. So that's fine what you're proposing to do now, but what about if you get this, what are you gonna do, as you say, be a good neighbor to make sure it ain't cluttered up in the future for those neighbors?
You're specifically referring to the shared property line with the residential
Yes.
properties? My client's certainly here to speak more to the specifics on that during public comment, but based on all of my conversations with Mr. Strobel, we're committed to, maintaining the current improved condition on that shared property line and being good neighbors. And just like we've committed to the condition with the landfill owner to the southeast, I think we would also be inclined to be agreeable to a condition that requires us to maintain that condition depicted in the former poster board that Mr. Whalen was holding up. Essentially, not just showing pretty pictures for tonight, but making sure that next year, 5 years, 10 years, that's what you get, a clean, orderly border with the residential properties to the north.
I'm glad to hear that because as far as I'm concerned and the person that appointed me, those people's homes is just as important as Kiowa or Isle of Palms.
Yeah, agreed, 100%.
Thank you.
Yes, sir.
All right, Ms. Smith?
Which property was the landfill on? The capped landfill?
So that's our property. That's what you're seeing on the screen right now. So the current scrapyard that my client is operating is on property that was formerly a landfill that has been capped since the Reagan administration. Now, there's an active landfill to the southeast that we've been referring to today that is currently a landfill.
Which property was that?
So that's the one to the southeast, TMS number ending 018.
And do you know the boundaries of the capped landfill that was on your property?
Yeah, so that is on the property designated 006 that's crosshatched.
Right. Was it over the entire property?
So Barry might be able to get into more of some of these technical details, but it's my understanding that this is one of these landfills that predates a lot of the current environmental regulation and registration, sort of like Brittlebank Park downtown. Like there's no permit for something like that. So it's not entirely clear where, like I can't pull a DHEC permit file out and lay that all out. We just know there's a history of landfill operations on site that have caused us to be very concerned about turning dirt.
Is there any sort of proof that there was a landfill on the site prior?
I can't hear the question.
Is there any proof that there was a landfill on the site prior?
Can you speak into the microphone? I can't hear a single word.
Is there any proof that there was a landfill on the site prior?
Dude.
So my clients, have owned this property since 1984. They know just from, the history of the area and talking to the people that they purchased the property from and just having knowledge of the property that there was a landfill there. I think Mr. Whalen and my client can speak more to the specifics about what they've, learned over the years on the ground.
And will we get a chance to see those handouts? Can they approach with the?
Sure, we have copies for everybody. If we may approach, we can distribute those. So 2 of the handouts are already in your packet. They're just sort of larger copies. The site plan has red X's next to the structures that have been removed or in the process of being removed to get to Board Member Jordan's question about overall cleanup. So all those red X's mean structures that are going bye-bye as part of this whole process. And they tend to be some of the least attractive structures on the property. The new exhibit is the one that references what Board Member Neal was talking about, the buffers with the adjacent residential properties. So there's been a lot of thought and effort that's gone into this to make sure that, we be good neighbors. And again, I mean, to be very clear, I mean, we're not coming here today with a request to build a bunch of new stuff. We were in the site plan review process and had to have a timeout called so we could obtain these variances to even proceed, because there were existing structures in the buffer zones. And in order for anything to proceed on the property, there needs to be resolution of these issues. So in other words, we're not here trying to amp up the intensity of this use on the property. We're trying to maintain the status quo, clean up the properties, and be better neighbors.
Any more questions, Ms. Smith? Mr. Truslow?
I have a question. Thank you for being here.
Yes, sir.
I'm trying to get my mind around, this was previously there was a medical waste landfill on your property, is that correct?
So there are indications that the landfill was of that character. It's, again, not entirely sure what's in there, what's not in there. But that is certainly a concern.
The reason I'm asking is my understanding is that DHEC and before that Land Resources has some very strict policies and information relating to closures of landfills and especially medical waste landfills. Do you have any of the documentation from, okay, I see your engineer may
Yeah,
have
this may
that
be a better
information.
question for Barry.
Ross,
Mr.
Mr.
Whalen.
Appel, one at a time, please.
Yep.
So Barry's coming up to talk to y'all.
You can defer to him.
Oh, I can defer
Sure.
to him right now, or?
No, you can.
When it's his turn to speak.
You can
Oh, I see. I
defer
see.
answering
Yeah,
my
well,
question.
Well,
and give-
let's let the experts handle that. But it's my understanding that this predates that regulatory regime, and that's not uncommon around this area to have landfills that sort of eluded the sort of modern cap permits, registration, all the things that we take for granted today. I think that's the issue here. But Barry can speak to that more when he comes up during public comment.
Mr. Neal?
Yeah, I just want to follow that. I understand all the questions that are being taken place are about the landfill, and they're here for a variance on a buffer and a setback, and that's what we should be focusing on. I'm not belittling anybody's questions, it's just the variance is for a setback and a buffer. So I don't know anything enough about landfills and the medical waste and stuff like that. That has nothing to do with what they're applying for. It does when it comes to the determination of should we be mixing up the ground and disturbing the ground and things like that, but they're not asking for a stricter use here. They're not asking for additional buildings. They're trying to leave it the way it is. So I would just ask the board to consider these things as we listen to the rest of the experts. We could sit here and debate toxic waste all night long, whether we want it to happen or not, but we're not asking for a use here. We're trying to look at the buffers and the permits. That's all I'm saying. Thank you, Mr.
Yeah,
Chair.
well, let's continue the public hearing. We'll get into discussion here shortly.
If I may just point one thing out real quickly, it's and I appreciate you saying that, Roy, but it's actually even better than that. We're not seeking a setback variance. We're seeking just a buffer variance. In other words, we are still committed to putting any future structure off the shared property line to the required degree based on the zoning code. We're just seeking buffer variances, meaning the requirement to actually plant things, right? So setbacks and buffers are similar in that they're defined zones around a property, but we're actually not seeking a setback variance. We're seeking buffer variances. It's essentially the planting, the turning the dirt, the disturbing the landfill, that kind of issue.
All right, any other questions for Mr. Appel? Thank you, Mr. Appel.
Thanks, everybody.
I'm pretty sure we have someone else here to speak in favor of this application. Mr. Whalen, if you would state your name and address for the record.
Whalen, 130 Dunham Avenue. This is a simple side of that when you have an older, I'll call it landfill or even suspected landfill, what happens, you have to go through closure even there. There has to be generally DHEC background information if you have a problem or if they're not sure that there's not a problem. There ends up being typically a process that comes to light and it ends up appearing on environmental regulation data sheets at Code Circle. There's different terms for some of the rest of this. So the fact that it has not become a known environmental problem and is not showing up on DHEC maps and resources as being something that's polluted or potentially polluted. Because if it was something like that, a real question, it would have to have been studied and looked at closer. Right now, it's capped, it's inertly, I'll say protected, and it is not turned into being something that has come to light as a problem. It's that simple. The rest of how it got started before Mr. Strobel bought the property in 1984, and it hasn't been an evaluation of that because no one's ever needed to ask for it. It was satisfied to just be kept. I'm not sure that that's a very technical explanation. That's sort of the seat of the pants of being around a while explanation.
All right, well, thank you, Mr. Whalen. Do we have questions for Mr. Whalen? Any questions? All right, well, thank you for your testimony. Is there anyone else here to speak in favor of this application? All right. If you state your name and address for the record and tell us what we should approve.
Sean Strobel, 1951 Stokes Avenue, North Charleston, 29406. I am the owner of the establishment that you guys are here to talk about. I'd like to address one thing, and that's with Mr. Jordan. He expressed some concerns that kind of threw me off guard. First of all, scrap yard don't make money throwing stuff in ditches. Second of all, I've never been cited not one time by any kind of code enforcer or anything for having any trash. So I'd like to correct you on that I make money off paper, cardboard, plastic, and metal. Recycling goes beyond just metal. So for you and I to understand, that is how I do it. Throwing stuff in the ditch doesn't work for any scrapyard if you're going to survive in this game. Second of all, I have a good communication with the neighbors. Matter of fact, one neighbor is here for the community. He and I have talked a couple of times. He actually owns a small business there. I have a good relationship with the lodge there as well. So there is no race in this thing, minority, majority, it doesn't matter. We're all going to do this thing. We put our pants on the same way. We leave the house the same way. We come back home the same way. That's how we do things. As far as what I'm trying to do here, I'm just trying to create a buffer with my fence and the vegetation. Losing 40 foot of my property on 5 acres, you guys would cripple me to begin with. And not to mention that we have been in business for years. And I think I have a pretty good relationship with most everybody that knows me and my company. And I want to keep it that way, which is why we're here trying to do the right thing. So all I'm asking you guys is tonight, think about it, listen to my neighbor, and just give me the best you can give me. That's all I ask for.
All right, well, thank you, Mr. Strobel. Does anybody have questions for Mr. Strobel? All right, thank you very much. Is there anyone else here to speak in favor of this application? Is there anyone here to speak in opposition to this application? If you would come forward, state your name and address for the record, and tell us why we should disallow this application.
Good evening. My name is Ricky Catino, and I live at 1902 Stokes Avenue, which is on that same street, but I'm on the other side of the street from his business. I'm here today representing for me and my family, along with about 10 to 11 other residents on that street, with 75% of them people being elderly people. They plan on moving and going no place else, and this is where they've been at for years. I've been over there now for almost 55 years on that street. My concern and question today is the safety of what he has to do. I got nothing against him running the business. I've been knowing him for a while. I too have a business on the other side of that street. But we were talking earlier on the part when I started looking back on the history of that Savage Yard. Prior to that Savage Yard, it was a medical waste dump site. When they first, whoever owned that property, sold dirt out of there, and later filled it back in. That which they filled it back in was medical waste. We just found this out. Everybody on that street just found this out not too long ago, last month, a month before last, when they had this case come up for the first time. For what he has to do and trying to do, my question is it safe on the part of the digging? how deep do he have to go, and it's going to be running into anything from that medical waste, because we live there. Me and those other 11 people on that street, along with that daycare center and the apartment complex, you know, we live there. And we want to make sure it's safe for us living there. If you got to put up more fence around the place, the higher you go with the fence, the deeper you have to go with those poles in the ground. Is he going to be running into any kind of contamination, you know, when he's doing that digging? So my question is it going to be safe for me and the residents on that street for what he's doing? If DHEC can tell me it's safe, no problem, you know.
Well, Mr. Patino, we're not DHEC, so
okay.
we can't necessarily answer the question about how the old landfill may or may not respond. But what we're hearing from the applicant and what he's testifying is the way that they're trying to implement their plans on the site by limiting any impact at all to that landfill for the purpose of being safe.
Okay, even with your limitation and everything else, as long as it's safe, but, you know, hey, I got to live there, you know, so I don't know how deep they're gonna have to dig and what all they got to do, and I guess that's you guys' job.
Right.
To see
We
that.
understand.
All
We
right.
appreciate your concerns.
Yeah.
Let
Thank
me
you.
see if there are any other questions up here. Mr. Neal?
Thank you, Mr. Chair. If he could point out on this map where he says he's on the other side of Stokes Avenue, if he could tell us what number his house is and then which number his business is, that may help as well.
It's kind of hard to make out, see from.
You can come
but-
up here if you need to just so you can read the numbers. We're looking at screens down here below us, so that's why we don't have to turn around. Are you number?
Down here on this
Yeah,
side. You have to come
you
through.
can walk around here and look, if Mr. Chair allows it. Sorry,
Yeah.
Mr. Chair. I have to wear my glasses, I'm blind.
The piece of property to your far right.
What's the number?
Right there, 043.
That's your house or your
That's my
business?
property where I live at. my
Okay.
home.
And you said you have a business there?
Yeah, I got a business, right here on 032, there's 2 sections of land. I got a hair salon and barber shop.
Nice.
On 032.
Okay,
And I own the property behind that too.
okay.
But I got family and friends and everybody on that street. I know these people, you know, all the folks.
That answers my question. Thank you, Mr. Chair. Thank you, Mr. Chair.
All right, thank you, Mr. Patina. Any other questions for Mr. Patina? All right, Mr. Jordan?
Go ahead. I hear you're concerned about safety, but before today, have you ever had any safety issues or problems with this company?
No. The only one we had in the past, one time before, a few years back, where it had an incident where one of the, I guess, automobile that they brought in, I don't know whether they didn't take the tank off or dealing with the gas on the automobile, it blowed up.
But they took care of it, right?
Say that again?
They took care of it?
Yeah, they corrected it. It shut things down for a while, our street, the railroad track and everything else, but they did correct it, and I had no more problem from them since then. I've never had no other problem
Thank
with the
you.
guy. It's just the safety part that we asked about.
Thank you, sir.
All right,
All right, well, thank you, Mr. Patina, for your time tonight.
thank you.
Do we have anyone else here to speak in opposition to this request? All right, you have an opportunity to rebut what you've heard tonight if you would like to stand up and provide a response. Mr. Appel, state your name and address one more time, please.
Okay, Ross Appel, 2036 E Wall Street, Mount Pleasant. I don't really have anything to rebut from the gentleman that just spoke. I just want to acknowledge that our interests are aligned here. We have the worst thing that we could do for the safety of the surrounding area is to comply with the county's landscape buffer regulations, because that would require us to plant an enormous amount of trees 40 foot deep on this entire property. If we were to do that, we would do violence to the landfill, thereby creating an assortment of problems. So this is a rare situation where there's some real alignment between, I don't even consider him to be opposed, frankly. I think we're aligned, and hopefully the information communicated today helps to put his concerns to ease. And again, we appreciate everybody's attention and the very good questions from the board. Thank you.
Thank you, Mr. Appel. Are there any other questions? All right, we shall close the public hearing portion of this application, and I will ask the board if there are any other questions of staff. There are no questions for staff, so we'll entertain a motion. Mr. Truslow?
I make a motion that we approve this variance request. It's been made pursuant to Zelda Chapter 4 and 9 for two purposes. One, to waive an 8-foot buffer, and also to waive a 40-foot type F buffer that's required for an existing salvage yard. This appears to be a capped medical waste landfill. It causes me some concern that we don't have any documentation, because in my experience, DHEC or land resources would have had specific requirements for capping, so everyone would know, the people in the community would know especially. Regardless, I would endorse what my colleague said, is here, we're really here to decide whether to grant a variance regardless. I would find that the 7 criteria for a variance set forth in section 3.10.6 have been met. I'm required to repeat those, because if there were ever an appeal, that we would have a record. So please forgive me, but we've got to do this in each and every case. I would find, number one, there are clearly extraordinary and exceptional circumstances and conditions pertaining to this piece of property. I'm convinced by the presentation that's been made. This is a 5.42 acre property. It was appears to have been previously used as a medical waste landfill that's been capped. That's caused everyone some concern. As Mr. Appel properly stated, one of the worst things to do would be to disturb this land now. That would create more of a problem for the neighbors than you have now. Number two, these conditions clearly do not apply to other properties in the vicinity. It applies to one specific piece of property that's got a problem, and it's clear this is the best way to resolve the problem. Number three, because of these conditions, application of the ordinance, if we were to strictly require compliance, it wouldn't serve any useful purpose, and it doesn't appear to be just. The authorization of the variance won't be of substantial detriment to the adjacent property or to the public good. In essence, the status quo will be maintained. Number five, the Board of Zoning Appeals shall not grant a variance to the effect of which would be to allow the establishment of a use not otherwise permitted. Clearly, this condition has been met. This salvage yard has been utilized on this parcel since 1984. Number six, the need for the variance is not the result of the applicant's own actions. In fact, it appears that the applicant's trying to correct some of the problems that pre-existed and improve the site. Before the salvage yard was established, it was used as a medical waste landfill, and the planning of the buffers, the issue of planning buffers is not as a result of the applicant's own actions. And number seven, the granting of the variance does not substantially conflict with the comprehensive plan or the purposes of the ordinance. To the contrary, this appears to be in the community's best interest. So that is my motion, and provided that the one condition recommended by staff is met, and that is that prior to zoning permit approval, the site plan that's in process will be completed. That's my motion.
Second. Before the second, are you including the agreement? There was
I'm
an
including
agreement.
the agreement and the commitment made by Mr. Appel that I believe will be placed in writing.
Second.
All right, we have a motion that has been made and properly seconded. Does everybody understand the second condition that was added just then?
Mr. Appel said they had a commitment with the attorney for nearby landowners to
maintain a setback, not necessarily a
maintain the
buffer.
setback lines as they exist at this
The
point.
shared use.
Right. All right. Is there any discussion? All right, all those in favor, please raise your right hand and say aye.
Aye.
That is unanimous again, so congratulations, your application has been approved. Within 10 business days, you'll receive final notice from staff, and please contact them to discuss the next steps in the process. So thank you very much for your time this evening. All right, Mrs. Working, our next case is BZA 0425000857, which is an appeal of an administrative decision.
Okay, I'm just going to briefly introduce the appeal before sending it to the appellate. And there are differences in order of hearing between zoning variances and special exceptions. So like I said, first I'm going to just do a brief introduction, like explaining where the property is located, et cetera. And then the appellant will have 10 minutes to present, and then you will have time to question the appellant. And then we will have Ms. Nikki Grimble is going to present staff's arguments, limited to 10 minutes, and you may question staff at that time. And then we will have anyone in support of the appeal for 2 minutes each, and anyone in support of staff's decision for 2 minutes. And then the appellant will have 2 minutes to reply to opposition, and you would close the public hearing to the public, and then state specific findings of fact and conclusions of law. And if you please note that these time limits can all be extended by motion and affirmative simple majority of the BZA.
All right, Board, do you have questions for Mrs. Working before we start this process? And I will add, I've been on the board now for 6 or 7 years, and this is the first appeal of a zoning administrator's decision that I've seen during my time on the board, so please feel free to ask questions. Mr. Neal.
My only question initially is it a simple majority? I saw a simple majority for the extension of the time. What is it for the final ruling and decision? Is it simple majority?
2/3.
2/3, and we have 8 here tonight? Okay, thank you very much.
Yes.
Any other questions?
I
Mr.
have a
Truesdale?
question. Do we have to, this is a unique situation we've never faced during my time here. Do we have time to think about it, or do we have to make a decision today?
I mean, we'd prefer that you make a decision today, after you hear all the evidence from everyone.
We're sort of in a quasi-judicial role. Most judges don't rule from the bench. They usually think about things for a while.
That's spoken like a former judge.
And then because they might need to articulate more of the specific findings of fact and conclusions of law, then you would have an opportunity when we're just briefly here. And we've got a lot of other people waiting. So I know you'd prefer us to make a decision now, but is there any requirement?
So I've been here quite a while, so I've seen at least 2 or 3 of these appeals. And I think if you just listen first, you'll be okay at the end.
All right.
Okay. Like I said, I'm just going to go over the information just for the record. Again, this is BZA 0425000857. The appellant is Ms. LaDawn Page, and she's represented by Jessica Monzo, Esquire of Keebler Law Group, LLC. The property is located at 1184 Bees Ferry Road in Unit 103 in the St. Andrews area of Charleston County. The tax map number is 30100000809, and the property is zoned Hunt Club Plan Development PD 73E zoning district. Also, we have parties of interest. Ross Appel Esquire of McCullough Con Appel is representing the property owner of TMS number 301 ending in 809, the Hunt Club Medical LLC. And the appeal is whether the Charleston County Zoning and Planning Department and/or its director decision to grant the permit zone 0325-22114 for the interior upfit for Chillax Vapor was an abuse of discretion and contrary to the lawful commercial use restrictions of PD 73E. The requirement is from the Charleston County Zoning and Land Development Regulations, Chapter 3, Development Review Procedures, Article 3.13, Appeals of Zoning-Related Administrative Decisions, Section 3.13.8, Approval Criteria. Findings of fact states, an appeal shall be sustained only if the BZA finds that the administrative official erred Decision of the BZA shall be accompanied by specific written findings of fact and conclusions of law, clearly stating the reason for the decision. Those written findings shall be delivered to parties of interest by certified mail, published once in a newspaper of general circulation in the county, and permanently filed in the zoning and planning department. And again, the Hunt Club Plan Development PD 73E guidelines apply to this property. The parcels that are in blue are in the plan development. Parcels that are in yellow are in the low-density residential, and red is community commercial, purple is industrial. This is the ordinance for appeals. This is the 300-foot radius that was notified for this case. Aerial photograph. This property was posted on May 15th, 2025. And this is pictures of the unit and the building and some of the surrounding businesses and the Hunt Club neighborhood. Okay?
Thank you, Ms. Working.
You're welcome.
Do you represent the appellate?
I do.
All right.
Good afternoon.
State your name and address for the record. And
Yes, sir. My name is Jessica Monsell of Keebler Law Group, and our office address is 700 Saturn Parkway, Columbia, South Carolina. I represent Ms. LaDawn Page, who's a homeowner in the Hunt Club subdivision off of Bees Ferry Road. Ms. Page takes issue, and I agree with her, that there are issues with how the Planning Commission has approached the issuance of a permit to, to two different applicants in this case on the subject property, which is adjacent to the residential area where many of the homeowners who are here today behind me, where they live and own homes. This appeal is not about a single homeowner's dislike of vaping or smoking or anything of that nature. This appeal was submitted because the Planning Commission issued a permit in violation of the allowed uses of the Hunt Club Plan Development, which is PD 73E. This amended PD was amended, the application for the amendment was made back in March of 2021 by the then developer owner. I actually brought, because of the volume of documents that are in the docket, I brought paper copies of documents that I would like to draw your attention to, but I don't want to create a procedural issue, so if that's problematic, I can hang on to these. Otherwise, I'd like to. Thank you.
are these copies for everybody, or is this just one copy of all of the documents that you wish to submit?
I believe there are 9 copies of everything,
Okay, thank you.
so each of you should have a packet. The top document that you're about to see is a memorandum from the then chairman of the Charleston County Planning Commission, dated March 14th of 2011. It's signed by the developer in March of 2021, acknowledging the Planning Commission's strong recommendation that applicants for zoning change requests to the PD work with the community to inform them of the request in order to potentially gain their support for such projects. And that's what happened in this case. If you turn to the next page, you'll see that there was notice given to homeowners at that time. And then the developer on the next page acknowledged the restrictive covenants of the property. And down at the bottom of the page, there's an explanation dated July 1st, 2007, citing South Carolina Code of Laws, Section 6-29-1145, which requires local governments to inquire into the permit application if a tract or parcel of land is restricted by a recorded covenant that is contrary to or prohibits an activity for which a permit is being sought. Reading from that statute, 6-29-1145, if a local planning agency has actual notice of a restrictive covenant on a tract or parcel of land that is contrary to or conflicts with or prohibits the permitted activity, paragraph 3 says, from any other source but not limited to other property holders, the local planning agency must not issue the permit unless the local planning agency receives confirmation from the applicant that the restrictive covenant has been released for the parcel of land of the appropriate authority or property holders or by court order. So that was a requirement of the developer at the time when they applied for the amendment to the PD in 2021. Ultimately, in September of 2021, County Council approved and adopted what's now known as PD 73E. And at that time, there were 3 removed uses that had previously been approved uses, although the commercial portion of the property had not been developed. And those were gas stations, convenience stores, and tobacconists. And unfortunately, the word tobacconist is an antiquated term, and that's central to the appeal today of this permit. If you turn to the next page, you'll see in November of 2024, an applicant named 540 Tobacco and Vape submitted a letter of intent saying, I'm trying to open a tobacco and vape shop at the subject address. And down at the bottom of the page, the section where it says approved use, it's blank. But the next day, a permit was issued to the applicant, notwithstanding the restrictions of PD 73E. When homeowners learned about the permit's issuance, and specifically my client, Ms. Page, called the Planning Commission's office and spoke with the deputy director, who told her, per my client, that there has been no permit issued, and she's correct. My client is correct that vape shops are considered tobacconists, and therefore no permit had been issued. However, if you turn to the next page, you'll see, well, January 7th, an email sent from the deputy director to the property owner stating that vape shops considered tobacconists are not allowed in this PD. In 2022, the developer who worked with the homeowners to amend the approved uses of PD 73E sold the property to the current owner, Hunt Club Medical. The deed, which was submitted as the supplement to the appeal, clearly states that restrictive covenants are in place and run with the land, in other words, apply to this property as acknowledged. What happened next, well, I'll say first that we submitted our appeal, I want to say March 25th, somewhere in that ballpark, but my client had submitted a Freedom of Information Act request to the Planning Commission and did not receive responsive documents until April 15th. So our initial appeal was submitted blindly, if you will. We had no idea as to what had happened and what went on behind the scenes. But the voluminous documents, which you may or may not have seen on the docket, reveal that there were a number of emails, telephone calls, and Zoom meetings that took place between counsel for Hunt Club Medical and members of the Planning Commission, the director, the deputy director, the county attorney, and staff. All to figure out how to fix this problem, this mistake that was made by the director in issuing a permit in November to a tobacconist. What follows next is a few pages of emails. And I apologize that they're in reverse chronological order, as emails sometimes appear. But if you flip to the page that has the number 16 at the bottom, Counsel for Hunt Club Medical writes, "Thanks for the call on Friday." This is addressed to the Deputy Director. "Just to confirm our conversation, the county has not rendered a final zoning interpretation on this matter and has not revoked the tenant's permit." And at the top of the page, the response is from the Deputy Director, "The zoning permit has not been revoked." Flipping back to page that's numbered 12, there is a settlement communication, as it's phrased here, from Counsel for Hunt Club Medical to members of the Planning Commission and staff and the county attorney, providing various alleged arguments for why tobacconists should be allowed under the PD. I call it the ZLDR. It sounds like y'all call it the Zilder. In the Zilder, there is a provision that says if a term is not defined in either the PD or the ZLDR, we must defer to the Merriam-Webster Dictionary 11th edition. So the dictionary defines tobacconist as a dealer in tobacco, especially at retail. But the dictionary does not define vape store or vape retailer.
Ms. Munsell,
Yes.
we have a little procedural matter that we're going to have to address right now because we've exceeded the 10-minute mark.
Gotcha.
And so at this point, I would need to entertain a motion from the board to extend her time if we so choose to do so. Mr. Seidel has motion, and a second from Mr. Truslow. Can I get a vote? All in favor?
How long?
How long, Mr. Seidel?
10 minutes.
10 minutes, a 10-minute extension. All right. All in favor, please say aye. Raise your right hand. Aye. That passes unanimously. Okay, you have another 10 minutes.
Thank you kindly. So vapes are not defined in the dictionary, and the planning, the staff of the Planning Commission offered the Merriam-Webster Dictionary definition for vape as a verb, not as a noun and not as a retailer. But if we turn the page to the one that has 13 at the bottom, Counsel for Hunt Club Medical suggests that because the plan development and the Zolder, neither of them address or define vaping one way or the other, their argument is that a vape shop should be an allowed use. He goes on to argue that the store should be able to sell limited tobacco retail sales as a commercial accessory, that it's common for vape shops to have a limited amount of tobacco products, and that we're prepared to have a discussion with staff as to what specific amount of tobacco retail sales constitutes an incidental and subordinate amount. So notwithstanding the claim that the applicant is not a tobacconist, there's still an intent apparently to sell some amount of tobacco on site. In that email, counsel for Hunt Club Medical also cites to cancer.org's website and definition of vaping, which I've included here if you turn past the emails in your packet. The last paragraph of the first section says e-cigarettes don't have tobacco, but many of them have nicotine, which comes from tobacco. Because of this, the U.S. Food and Drug Administration classifies them as tobacco products. And not incidentally, so does our state legislature. In the appeal that we filed in March, without knowing any of what went on behind the scenes, it was our position that in the absence of a definition either in the plan development, the Zolder, or Merriam-Webster's dictionary, that the best source of definition for a tobacco retailer is our state statute, which clearly defines what that is. South Carolina Code 16-17-501 has a lengthy definition of tobacco retailer, and about half of it, I'm sorry, it's tobacco products. Half of it, half of 10 paragraphs refer directly to vaping products. The Merriam-Webster dictionary does define e-cigarette as a noun, which is a battery-operated device that is typically designed to resemble a traditional cigarette and is used to inhale a usually nicotine-containing vapor. What went on during this timeline that I've provided to you is that while the staff and the attorney were trying to figure out how to get a permit for a tobacco and vape shop, a second application was submitted from a different company applicant called Chillax Tobacco and Vapor 3 LLC. Both applicants, 540 Tobacco and Vape LLC and Chillax Tobacco and Vapor LLC, or 3 LLC, are registered with the South Carolina Department of Revenue as tobacco retailers. Furthermore, our Charleston County Public Library system is a smoke, vape, and tobacco-free property, which you can see. This picture was taken at the James Island County Library a few weeks ago. And if you turn to the next photograph, you'll see there's a prohibition on smoking, vaping, electronic smoking devices, and tobacco use of any kind on the property. The same prohibition applies at Charleston County Parks. And for reference, I've also included what's being done in some other jurisdictions, including Greenville County, which provides a public health, first groups vape shops and tobacco shops together. This is on the final page of your packet. And states that while adult smoking rates have significantly declined over the past 50 years, smoking remains the leading cause of preventable disease, disability, and death in the United States. And states everything that we know about use of tobacco and smoking broadly. But they specifically included vape shops in this categorization. And then they go on to state that a new vape shop or tobacco shop must be located at least a quarter mile or 1,320 feet from any lot zoned, and then you see all of these categories, which are primarily residential, but a vape shop or tobacco shop cannot be located near an existing vape shop or tobacco shop. Any dwelling unit, any lot containing a daycare center, preschool, or school, any lot containing a park or playground, any lot containing a hospital or nursing care facility. Finally, I know this has been long, Charleston County Schools in 2021 filed lawsuit against Juul, Altria, Philip Morris, Big Tobacco, for lack of a better term, claiming that that this is an epidemic. Vaping is an epidemic in Charleston County schools, and that the biggest growth population amongst users of vape products are in the age range of 14 to 24 years old. And those are the target, that's the target audience for these products. And frankly, this is why the homeowners and the developers in 2021 didn't want this to be part of a family-oriented commercial section of a neighborhood. I'll address any questions you may have.
All right, thank you for that. Board members, we have an opportunity to ask the presenter questions. Do we have any questions? Mr. Neal.
Thank you. Thank you for that presentation. I still have some questions internally here on the exact layout. I would imagine that, okay, just I'm not real smart here because I got lost in a lot of the details that you were providing about the Charleston County Library and the schools and all these other things about the horrors of vaping. I'm not going to say what's good about them all. I'm trying to whittle down to, did somebody make a mistake, or was there a judgment that you disagree with? And then what it sounded like, and please correct me if I'm wrong, is that your clients don't like the decision that was made on the definition of vaping. And since it's very clear in a gray area in the PD, it's not listed as a use, so the zoning administrator allowed it. But you believe, or your clients believe, that tobacco, any sale, is not warranted because of the violation of the PD agreement. I kind of comparing it to the booze pops downtown. The booze pops, everybody says they have liquor in them. Well, they have liquor up to 8%. Well, the state of South Carolina says that's not liquor, so you don't need a liquor license. So there's a lot of gray areas. Is that really liquor, and can they sell liquor? And it seems like your arguments were, well, they're selling tobacco because there's a piece of tobacco in this product. And I'm looking at it like, well, yeah, there may be some tobacco in. I'm not smart enough to know if there's 1% or 8% or whatever, but it sounds like the zoning administrator to me made the argument that this is not a tobacco sale. Even though it might have some in there, this is not a tobacco sale and not a retail sale. So barring all the terrible things that vape may be doing in the schools and stuff, please zero in on your argument for me on why this can't be done or allowed.
Sure, thank you for your question. So the issue here is that the tobacco, or the tobacconist term, is an antiquated term, and we're trying to determine what is the modern usage of that term. But if the zoning director or the planning director has determined that vaping is something completely separate and apart from tobacco use, despite a state statute that says otherwise, despite what other institutions within Charleston County have determined, then the director has essentially created a new use within the plan development without going through the proper amendment process.
Mr. Chair, may I follow up? So that's what I'm trying to boil this down to. Is where, in your opinion, did the zoning administrator make a mistake? Is it in the interpretation of the tobacconist and the definition, or is it in the use, and they should not have done it? Because I just don't, I'm trying to understand your argument to show where the zoning administrator made a mistake, and I don't see it.
Right. So it's our position that, given the fact that there is a state statute on point, which is 16-17-501, which at great length defines what are tobacco products in the state of South Carolina, that should have been the source of information that the director should have deferred to. And to give you an analogy that may help understand the way that I see this issue, we also said that convenience stores and gas stations were prohibited uses in the plan development. Now, if I were to submit a permit application for a diesel-only station, would that be permitted or not? There are a lot of trucks that go down Highway 17 and they use diesel, so could I set that up, or would that be in violation of the spirit of the plan development as it was developed in cooperation between the homeowners and the developers?
Well, then, in my last question, Mr. Chair, your remedy here is to overturn the decision, which would take away the, I would imagine, take away the permit and stop the action. Isn't the remedy here with City Council and making the ordinance a little bit more defined and clearly, or in the PD, making sure the PDs are defined clearly for this gray area of what is tobacconist, instead of a remedy? You're asking for the remedy to overturn this.
The remedy we're seeking is to revoke the permit, and
Yeah.
we're not within the jurisdiction of City Council, but if, in essence, if by allowing this loophole or carve out, if you will, for the applicant making an unenforceable promise not to sell tobacco is creating a new use, then they should have gone through the amendment of the PD. And that's a lengthy process that the former owners did in 2021.
Thank you, Mr. Chair.
Mr. Truslow?
Thank you, Mr. Chairman. I have two basic areas for questioning. Number one, if we reverse, would that simply mean that the matter would go back to staff to perhaps make a better record as to whether the term tobacco is an antiquated term, or would this be the end of it and this would be disallowed? What do you contend would happen?
Well, that's a procedural question, and I'm not sure I can answer. I can tell you the relief that we're seeking is the revocation of the permit. Whether that's something that is that needs to go back to staff for further deliberation, that's a question I cannot answer. But it's our position that it was a permit granted in error, and the evidence that there's an error here is the fact that a permit was granted, a second permit application was made, and the second permit application was granted, and then subsequently the first one was revoked, which clearly tells me that the vape shop intended to sell tobacco, still intends to sell tobacco per its attorney, and really just shouldn't have, this should never have been issued in the first place.
Mr. Truslow, so they're questioning the director's discretion to make the decision. So it is the director's decision that is before the board.
Then the second part of my inquiry is this. What do you contend is the standard for us to apply? Is it clear and convincing evidence? Is it an abuse of discretion? Is it just more likely than not? What do you contend is our standard that we should apply?
Well, there's case law, and I can cite to it in just a moment, that says that when imagining that we were before the circuit court, and I understand we're not there, that we would contend that this was an error of law, because when a state statute is on point, you can't ignore the plain language of a statute to have what the Supreme Court has called a forced interpretation of whether it's a regulatory interpretation or otherwise.
So your contention is that the wrong definition was applied? Oh, excuse me, the wrong definition was applied in this case to the term tobacco?
Because not to the term tobacco, but that because there is no definition of a vape shop in the PD or the Zilder, and because there's ample definitions within the state statute, that the director should have deferred to the state statute, which is 16-17-501.
Okay. The last area that I would inquire about now is, do you contend that we can take judicial notice of FDA and and Center for Disease Control definitions in this case?
I believe you can, and I don't know if that's a regulatory question again for
right.
your colleagues. But these are some of the sources that are being offered by the other side. So, I mean, all of and I think some of the homeowners will comment on this, there are many, many public agencies, whether they're health-related or municipalities, that group tobacco retailers and vape shops together. Even those cited by Council for Hunt Club Medical, Columbia's definition has them together.
All right. Then the last part of this, and then I'll be done. I think we all know that nicotine is an alkaloid similar to strychnine. It's derived, you get it from tobacco, specifically from tobacco. I don't know of any tomatoes, potatoes that aren't used to obtain nicotine on a commercial level. Or is it your contention that that nicotine in this instance is the equivalent of tobacco?
Nicotine is derived from tobacco, so yes, that would be a fair statement.
All right. Okay. Thank you.
And I would like to add one point that I omitted earlier, and that relates to Exhibit 12 that is in your docket. These were letters of support that were submitted from commercial tenants. And under penalty of perjury and as an officer of the court, I would like to make it known that on Saturday morning, so 48 hours ago, I was contacted by a commercial tenant who had submitted a letter in support of the vape shop and told me that it was not explained that this was a zoning dispute and that the tenants were misled and told that this was about one homeowner protesting because she doesn't like vaping. And I know that y'all have subpoena power, so if you want to investigate that, that's your decision whether or not you want to do it. But commercial tenants, at least one of them told me that they were misled about the issue here, and on that basis submitted a letter of support for the vape shop.
When we get to the public comment section of this, we can ask if one of those tenants is available to come forward and make that statement. That would be very helpful as well.
Understood. Thank you.
Mr. Seidel?
I just had one follow-up question. Yes, nicotine is derived from tobacco, but also nicotine can be synthetic nicotine from chemical compounds can also be made, right? It's identical to the nicotine from tobacco. Is that correct?
Well, although I'm not an expert in the contents of vaping products, and I think probably staff will make reference to something that is addressed by our state legislature in 16-17-500, and that is that there is a preemption section of the statute. So the state legislature has decided that local governments, municipalities and the like, are not permitted to enact laws that regulate the contents of vaping products, vaping cartridges, liquids, etc. And then following that restriction, there's what's called a savings clause. And the savings clause says, and I want to quote it accurately, the savings clause says that nothing in this act shall be construed to interfere with a political subdivision's authority under Chapter 29, Title 6, including without limitation with respect to land use regulation, land development, regulation, zoning, or permitting. And what the attorney for Hunt Club Medical would tell you, and I'm sure he will, is that that means that nothing in this statute applies to anything we're talking about here today. But that's not what a savings clause does. What this is saying is that the zoning authorities in Charleston County actually retain their authority where it pertains to regulation, zoning, or permitting, regulation of land use. That does not mean that the statute has no application or no bearing on anything in Charleston County. Otherwise, we could just ignore it wholesale and move on. So to your question, I couldn't speak to synthetic versus naturally derived nicotine, but our state legislature in this statute has said that those contents are not to be regulated by local governments, that those contents are preempted, I believe, by federal law.
Thank you.
All right, do we have any questions down here? All right. Well, Ms. Monsell, thank you so much for your presentation.
Thank you all for your
this evening.
patience and consideration.
All right. Is the representative for the county present?
Hello. First, I'd like to take a moment to go through just some background to help everybody understand the formatting of this presentation. It refers back to...
We do need your name and address for the record,
I'm sorry.
please.
It's Nikki Grimble, 1768 Santee Street, Charleston, South Carolina, 29412. I'm a staff member of the Charleston County Zoning and Planning Department.
Thank you.
So the staff report that was provided in all of your packets today was about 8 pages long and had a ton of words on it. So I've tried to make this presentation clear where it's taking all of staff's responses to each of the claims in the statement of case that the appellant provided and kind of group them into different categories so it's a little bit easier to follow. So in the packet, you'll see that there is the timeline, which explains all of the events that have led up until today. And then after that, we responded to each claim made by the appellant in their statement of case.
Mr.
And
Chair,
then,
what exhibit are we looking at? So I can't find the same exhibit that's on the page.
this is just your regular staff
It's the one with the
report.
case packet number. It just says the case number.
Yeah, it's, what's the case
I don't see it. I don't. Thank you.
It's the one that's BZA 0425000857. Doesn't have Exhibit 7, Part 1, or Exhibits 1
Yeah,
through
that's-
6, or...
This is,
Yeah, keep going.
this one? Okay. Thank you. Sorry for interrupting.
No, no problem.
It's this one right here.
So to be a little bit more concise, I made the categories based on the claims that were made. So of those 5 categories, the first one is responses regarding the letter of intent and the zoning permit. The second is in regards to interpretation and definitions. The third is in regard to the South Carolina Code Section 1617-500. The next one is the allowed uses in Hunt Club PD 73E. And the last is the claimed abuse of discretion in issuing the zoning permit. To date, there have been 19 zoning permits issued that are from our department that are worded very specifically to contain the term tobacco or vape, or where appropriate, both terms are used. All businesses are held to the extent of the language provided on the permit, meaning that if something is found to be out of its scope that it's allowed, then they would be subject to a ticket that could be issued by our department and our code enforcement officers. In this specific case, the zoning permit that was issued removed all references to tobacco, just to be clear and concise that the proposal was only for vape products. So in the first category, the responses regarding the letter of intent and errors in issuing the zoning permit. The letter of intent prohibits tobacco sales and smoking on site. And as far as the zoning and planning department's concerned, vape shops are considered retail sales, which is actually expressly allowed in the guidelines of PD 73E. There's no mention of vape shops contained in the PD guidelines, and the interpretation that was provided by the appellant attempts to force a vape shop within the definition of tobacconist. And just for reference, tobacconist is actually not a use that is in our use table anymore. That has also been put into a larger grouping of retail sales as is vape shops. Also, just for clarity, the original zoning permit was not denied or revoked until the new zoning permit was issued. It was simply put on hold in order for staff to investigate and make further determinations based on the information we received from the appellant and also the information that we received from the applicant's attorney. Responses pertaining to definitions and claimed forced interpretation of uses. Article 12.2 of our zoning ordinance requires staff to use Merriam-Webster's dictionary for any terms that are not defined in the ordinance. We use this pretty frequently. It is not something that we are questioned on because it is laid out for us directly in the ordinance. It tells us exactly what we're supposed to do when there is no definition provided. It is the opinion of the appellant that the department provided a forced interpretation of uses allowed and prohibited in PD 73E. However, the department has shown strict consistency in its interpretation of the term vape shop, which is a use that falls under retail sales. Contrary to the appellant's statements, the applicant specifically limited the range of products sold to exclude any tobacco products and smoking on site. The appellant claims that the department is bound by the regulations set forth in South Carolina Code Section 1617-500, which is an act intended to restrict and establish penalties for the sale of tobacco and other smoking products to minors. Section 4 of the act specifically states, "Nothing in this act shall be construed to interfere with a political subdivision's authority under Chapter 29, Title 6, including without limitation with respect to land use regulations, land development regulations, zoning, or permitting." Charleston County is a political subdivision of the state of South Carolina, and therefore the definitions, regulations, or any other direction the appellant provided in support of her case has no bearing on the ZLDR and is not applicable to the way in which Charleston County defines its land uses, administers its ordinances, nor restricts its ability to issue permits. In response to the claims that the department failed to uphold the allowed uses listed in PD 73E, staff provides that the approval of Hunt Club PD 73E contains conditions, one of which removed tobacconist, among others, from the list of allowed uses. While tobacconist was removed from the list of allowed uses, it was also not included on the list of prohibited uses provided in the guidelines. Vape shops are not mentioned in the PD and therefore are addressed as they would be in any other application for this type of use in Charleston County as a retail sales establishment. Retail sales have always been listed as an allowed use in the PD guidelines. There are many other types of uses that fall under retail sales, so that's not just limited to these specifics, but they're in a zoning ordinance amendment kind of overhaul in 2021, later in 2021. Many uses that were listed in our use table were all moved to be considered retail sales. The appellant claims that by issuing zoning permits for a vape shop is an abuse of discretion. Based on the facts presented, issuance of the zoning permit does not amount to an error in law, and the department has in fact followed the law and administered the Hunt Club Plan Development and the Zoning and Land Development Regulations Ordinance consistently since the time of their adoption in 1999 and 2001 respectively. Charleston County staff administers the ZLDR fairly and consistently across Charleston County, which includes making decisions that may not be popular or assumptive, but are quite literal interpretations of the ordinance and/or statute of state law at hand. South Carolina legislation expressly stating that application of said statute does not apply to zoning or land development regulations will not be considered in the administration of this ordinance at any time, no matter what the argument may be to prevent or allow an application to move forward. While in retrospect it may have been the appellant and/or the community's assumption that a tobacconist use designation and restriction could cover any and all renditions of a smoke-type retail store, it is not an assumption that county staff has made in the past. Doing so would be arbitrary and capricious and reprehensible by law. I did want to respond to one thing that the appellant claimed regarding the FOIA request, just for clarification. She mentioned that the staff provided the FOIA request very late in the game after they submitted their application for appeal. We actually provided that information 4 days prior to our deadline to provide it based on state law. And we also gave the applicant an additional 5 days to provide their supplemental case before it was presented to the Board of Zoning Appeals. So we did try to give a little bit of wiggle room, given the fact that the FOIA request was pretty extensive, by allowing them an additional 5 days of what they would normally have to provide a response. And I will answer any questions.
All right, well, thank you very much. My first question is, I know you've testified that the county has lumped vape shops in with retail sales in other examples. Did you provide examples of that within the information that was submitted?
I did not.
Okay. It might be helpful to have some examples.
Okay.
All right.
Oh, would you like for me to?
Go ahead, if you have a few.
I'll actually defer to our zoning administrator, Sally Brooks, of where some of these other cases may have come into play. But maybe while she's looking that up, we can go to other questions.
Yeah, we'll see if there's other questions. Mr. Neal?
Yeah, thank you, Mr. Chair. So just making sure I follow the events that are being claimed that by the appellate, I guess. I'm not good at these legal terms. And actually what happened in the response from the county, there was 2 applications. The original application, which is being stated that was revoked, was not really revoked. You're presenting evidence that it wasn't revoked. It was just delayed until you could get the definitions or deal with internal discussions. And then at the same time, a second application was put in. And in the first application, it mentioned tobacco products and things like that, but that one was either never ruled on or withdrawn. And then the new application, so I don't really care personally about the first one now. It's the second one that came in, and the second one had no mention of tobacco.
Correct.
And then it was approved, but it was also approved almost with conditions that clearly reinforced the statement of no tobacco sales.
Correct.
So I'm trying to understand that where there is a mistake. I mean, if you made a point to reinforce that there is no tobacco, you are making it very clear that this retail shop, which is lawful under the PD, lawful under all the requirements that the county has, there couldn't be anything more clear than stating that there will be no tobacco here, right?
Correct, yes.
All right. Mr. Jordan?
And when this delay was done to approve it or disapprove it, did they still get a permit?
So the first permit was issued, and that was based on the fact that we would consider all of these as retail sales in general. So it did take the appellant to point out the fact that they had gone through these iterations and had these conditions of approval to the last PD amendment, PD 73E, that removed tobacconists as an allowed use. Like I mentioned a moment ago, it did remove it as an allowed use, but it did not put it on as a prohibited use. So it was something that staff, it just didn't come. You have to kind of dig into the history to understand where this, removal and prohibited and, the definition and everything kind of going into retail sales establishment use type kind of come into play to see where that.
But shouldn't that decision been made before you issued a permit?
Well, the permit was issued based on the fact that they were both considered retail sales. So upon, notification of the appellant mentioning that tobacconist, which again, we don't consider a vape shop a tobacconist, that a tobacconist was not allowed. It was removed from the list of allowed uses that was originally proposed. But since it wasn't, flagged as something that was prohibited, it kind of got lost in the mix.
Okay, so there'll be no tobacco sold at this place, right?
Correct.
Well, this will sure be a unique one because every vape shop I've ever seen has tobacco in the window.
Well, nicotine sales would be the only thing that that would be tobacco related in this particular vape shop.
And the third thing I have, Mr. Chairman, is you told us how many days before the deadline for the FOIA request. How many days after you received the request did you act?
We actually had we had 30 days to provide the information based on the fact that they were requesting emails from multiple different departments, and we had to do certain search terms to include all the applicants, their attorneys, and the like. So that allows us a little additional time to collect the information.
So how many days does that compute to?
I guess
made the request.
Minus the 4 days, we provided it within 26 days.
Thank you.
Mr. Setup?
So when you made the ruling in terms of providing the permit to the applicant, did you incorporate language in that approval based on what the appellant had submitted?
Yes, so the permit language is pretty detailed, surprisingly, where it identifies things like the hours of business. Usually it will have how many people will be working at the store, but it also, in this situation, it specifically states no tobacco sales are allowed and no smoking on site.
So I'm not really understanding why, since the application did not include any reference to tobacco, and you've said that vaping is classified as retail, why you would mention no tobacco sales in the approval?
I believe that, it was...
Seems to acknowledge that there's confusion
True.
there between what vaping does and what tobacco is.
I can see where you would see that. The letter of intent, which is actually what all of our zoning permit language is based on. So we take exactly what the applicant gives us, and they wrote that on the letter of intent to specifically address this issue that had come up previously with the original zoning permit, knowing that that some of their surrounding neighbors had issue with this, what they thought was a gray area between tobacco and vape. and how the county should define it and acknowledge it. So they were being a little proactive in that matter of specifically saying that they would not provide any tobacco sales on site.
So they modify or they characterize what they would be doing in this retail establishment to eliminate any kind of reference to tobacco,
Yes.
knowing that there's an association there with tobacco.
I think it was the association with the disallowed use of tobacconist. So by removing the acknowledgement of tobacco in sales in their store would remove any question that they were a tobacconist in their mind.
Okay. Can I just follow up on that?
I want to ask a question.
Yeah, I
first.
was going to ask for the letter of intent. See it.
All right, go ahead, Mr. Neal.
Yeah, the thing you just referenced for Mr. Seidel, do we have a copy of that letter of intent that shows that they made the detail of mentioning this type stuff so that we could come back and say, this is why you responded the way you did? And then that would clarify things a lot easier, for at least for Mr. Seidel's question.
Yep, so it's up on the screen, and it's there is Exhibit 5 is the letter of intent, and Exhibit 8 is the actual permit.
Yeah. Thank you, Mr. Chair.
You're welcome. So my question is I want to understand the timeline a little bit better about when the word tobacconist was removed from both PD 73E and from Zeldar. And did both of those occur in 2021?
The tobacconist as a use was, when did the ZLDR amendment process begin? That ended in 2021? Okay. So October of 2021 was when we had our big overhaul of the zoning ordinance and tried to narrow down the use table, make it more applicable, remove uses that had never been used before, and combine them where we possibly could. So that was in October of 2021, and the PD amendment process that was adopted by County Council in September of 2021. I believe that the discussions between the owner and the community regarding these, removing some of the uses that the owner had provided were done after the Planning Commission process, during the Planning Commission process. So that would be the first step. Planning Commission would occurs, then they, work through their issues before it was presented to County Council for approval.
Okay, so it wasn't necessarily done to bring PD 73 up to a point where it was consistent with Zeldar. It was a completely separate process.
Correct.
Okay, all right, thank you.
Great question.
Any other questions? All right, thank you for your time this evening.
Sure.
Ms. Working, what was next? So, Mr. Appel, I believe you have the opportunity to present now.
So we're going to do in support of the appeal.
So, okay, we're starting with
in support of the
appeal.
appellant.
Sorry, Mr. Appel.
Yeah.
You shall get your opportunity.
So you guys received on Friday the 38 comments.
All right, thank you. I know we have a number of people here to speak in support of this appeal tonight. What I'm going to ask is, one, we're limited to 2 minutes per person, correct? Please, if your comment is the same as the last person that went before you or some person that went 5 people before you, please refrain from speaking. We'll understand that we'll have multiple comments that are repetitive tonight, but the board really needs to hear new information to support the reason for the appeal. So please keep that in mind as we go through this process tonight. So with that, who is coming to speak first in support of the appeal? Yes. Please come forward. State your name and address for the record, and please.
My name is LaDawn Page. I live at 886 Hunt Club Run. I am in the PD that is in question. I am, can you hear me now? I'm
Yes.
sorry, I don't have 20 minutes to talk. I am the appellant, and I am the resident that spent 5 months negotiating the types of uses that would be allowed in our PD. we made it specific to say that gas stations, tobacconists, these kind of uses do not support the intent of our PD, and that is a very, very important thing when you're looking at zoning. Our other concern is that I had to call the county and tell them that they made a mistake. You know, we said no tobacconists. Well, I had to call them January 7th, and if you look at that letter, I think it's on page 112 of your information of emails, Deputy Director told Jack Coupland that tobacconists, vape shops are not allowed. So why didn't they revoke a permit, knowing that it was issued in error, and allow it to go to an appeal? Just what I'm doing. I'm appealing a process. Why was it not revoked? Instead, it was allowed to be discussed behind closed doors, which also makes me question, do they even care what we think? I think a really big issue with zoning is that its intent is to protect the public, and that's not what this is doing. I think the other concern is you are changing a use. We negotiated. If I had had the chance to negotiate with developers that we didn't want a vape shop, I would have done it, but it was redundant. I mean, they were considered tobacconists. Why would I do that? And then furthermore, you have a PD, and if you're changing our PD, then that should go to the Planning Commission, and it should also go to County Council, because that's why we're here today. I shouldn't be arguing why the county made a mistake. And so I just respectfully ask that you will pay attention to what the community members have in their concerns. And I greatly appreciate your time. I know it's been a long one. I should buy you dinner. Thank you.
Thank you, Ms. Page. Are there any questions for Ms. Page? All right, you're good. Are you okay? Yeah, thank you. Ma'am? Please state your name and address for the record first, and then hand the documents.
My name is Rebecca Heilman, and I actually have a map showing you where I live in relation. I can see for everybody. My name is Rebecca. I live in 1183 Quick Rabbit Loop, and I can actually see this from my backyard. I do have a master's in public administration, which included studying community planning. Residents gave clear input in 2021, no tobacconists, no gas station, no liquor stores. The definition of tobacconist includes vape shops, yet a permit was issued for a vape shop. Months ago, I called the zoning office, and I spoke with Joel. He admitted to me that he did not fully understand vaping, and then he said he was going to have to call somebody with the city to learn a little bit more. I really hope that wasn't Councilman Appel. Joel said that the shop said that they would not sell tobacco, and he was going to leave it up to the legal team. But the county does consider vape shops as tobacconists. Redefining it as a separate use to allow it in PD 73E should qualify as a major modification under Zaldar 4.25.10B.2. This is a failure of due diligence. Decisions should be based on facts, not confusion or influence. City Councilman Ross Appel is also the developer's attorney. That is a conflict that blurs the ethical line between public service and private interest. The city and the county may be separate entities, but our community is one. Yes, I have public health concerns. A family I know nearly lost their 16-year-old to vaping-related lung issues, and teachers will tell you that vaping amongst minors is rampant. But this is about planning, transparency, and integrity. Adams Property Group, see those documents in front of you, marketed Hunt Club Village as a healthcare destination. Their LinkedIn post praises Somerville Pediatric Dentistry, highlighting child-friendly healthcare. Their website, see that as well, describes it as a family-focused shopping center with tenants thoughtfully placed based on community feedback and desires. That is their language, that is not mine. It paints a picture of safe, health-oriented space. A vape shop isn't just inconsistent with zoning and the PUD, it is inconsistent with their own public branding. So I ask this board, how does a vape shop fit that intention? If a tenant selection was truly based on community input, then this decision defies the very promises made to the public. If we ignore the public good, what is the point of a PUD? Thank you.
Do we
you
have
any
questions
me?
for this presenter? All right, thank you for your time. Please state your name and address.
Hi, my name is Jennifer Klinner. I live at 851 Byberry Court, Charleston 29414. I was part of the group in 2021 that negotiated with the developer about the things that we were removing from the potential commercial development. And I can tell you that we never in our wildest dreams would have thought we needed to go into minute detail about defining what each of these categories are. And that happened before this change to the Zaldar that I am hearing about tonight. It feels very much like we had the wool pulled over our eyes, where we agreed to something using the term tobacconist, which at the time was in the Zaldar. And not even 6 months later, it disappeared. And now vape shops are a retail use. And this was never the intention. Our effort was to protect the desires of our community, and there is nothing that I can find in Charleston County that I've searched that showed me where there is a different definition of vape shop from tobacconist. So I have to fall back on the SC Code 1617-501. And I found sort of a dummies version that explained it to me. It was by the Public Health Law Center. Very simply asked, are e-cigarettes in any section of the state statutes included in the definition of tobacco product? The answer is yes. It asks, how does the state define an e-cigarette? The answer, electronic smoking device means any device that may be used to deliver an aerosolized or vaporized substance, including e-liquid, to the person inhaling the device, including but not limited to an e-cigarette, e-cigar, e-pipe, vape pen, vapor product, and also includes any substance intended to be aerosolized or vaporized during the use of the device, whether or not it includes nicotine. That is the state code. It is including vape and vape products under the definition of tobacconist. And if we are going to ignore that, I guess we're going to ignore everything. Thank you very much for your time tonight.
You have a question, Mr. Neal?
Yeah, I do have a question.
Yes.
I'm hearing comments about the group that negotiated with the developer, so I thank you for your time to help your community, and you were foreseeing these issues coming out. But if you were negotiating on what uses you did not want, were you provided a list of uses from the county at the time that stated what could be in and what could not be in? And I'm trying to locate where the mistake that is being referred to was made, because currently I don't see the mistake. I see gray area, but I don't see where it was clear that vape shops were in an area and now they're not in an area, they're in retail shops. So is there any type of form or any type of detail or guidance that the county gave you when you were negotiating on the behalf of the community with the developer on vape shop would not be in retail and it would be in tobacco and it wouldn't be used? Or is it just you assumed or your group assumed?
Well, I will say LaDon has more of that background information than I do,
Okay.
and it's been a few years.
Okay.
But I can tell you that, sorry, I have a medical condition, I get brain fog, and I just
That's
lost my
fine.
train of thought. At the time, I don't feel like we got into detailed definitions of each of these categories. It was more of a general discussion about what our community did not want.
Right.
We did not want fast food. We did not want gas stations. We did not want the liquor stores. We didn't want the tobacco stores. And from what I understand, at that time, vape stores did not exist as a separate category or entity anywhere.
Well, I just want to follow up, Mr. Chair. So I'm just making sure the county didn't provide you or the group didn't ask for any guidance on the definitions or these uses or anything specific to vape stores or tobacco.
I don't remember those specifics. I do not remember a specific definition of each category being provided to me personally.
That's fine. Thank you.
During our meetings.
I
Thanks.
appreciate your comments.
Yeah,
Thank
appreciate
you.
it.
Thank you for your time.
Thank you, Mr. Chair.
All right. And who's next to speak in support of the appeal? When somebody come speak.
My name's Diane Milligan. I live at 1134
Can you
Idbury.
lower the mic
Oh.
so we can hear you?
My name's Diane Milligan. I live at 1134 Idbury Lane in Hunt Club. And don't feel like I can compete with all this talent. I begin by citing Deputy Director Miloxic's white email dated January 7th, 2025, addressed to Jack Copeland with Adams Property Group, who is the current owner of Hunt Club Medical LLC. Quote, per the council approval of the most recent Hunt Club Plan Development Zoning District Amendment, vape shops considered tobacconists are not allowed, end quote. Therefore, the November upfit permit for 540 Smoke and Vape should have been revoked immediately upon knowledge of the county's error, preventing due process of formal appeal before the BZA and allowing discussion behind closed doors erodes public trust that our county considers the concerns of its citizens. exploitation of the rule of strict construction to justify permitting a vape shop circumvents the intent of this PD and furthermore fails to serve the best interest of the community. The state DOR and NAICS code and state statute, the FDA, the U.S. Census Bureau, all define and classify vape shops as tobacconists, but the county fails to recognize this in favor of an archaic definition. According to the American Planning Association, it's recommended and is commonplace that zoning boards reference the NAICS codes when determining land-based use classification. It's not unreasonable that vape shops are zoned and subject to the same restrictions as tobacconists. Excuse me. When making the final decision, I respectfully ask the BZA to consider the public health aspect of these establishments as well. Vape shops do not align with the zoning intent or our community, nor do they meet the general purpose of zoning, which is to promote and protect public health, safety, and general welfare. Thank you.
Thank you. Mr. Seidel, you have a question?
I'm sorry, I didn't catch, you were giving us a quote at the very beginning.
Yes.
Who was the person who made that statement?
Deputy Administrator.
The Deputy Director, MELOSIC White. He sent an email dated January 7th, 2025, addressed to Jack Copeland with Adams Property LLC, who's the current owner of Hunt Club Medical LLC.
Mr. Seidel, this is an email that's in our packet
Okay.
from county staff. All right, thank you very much for your time.
Thank you.
Ladies and gentlemen of the board, my name is Park Page, and I live at 886 Hunt Club Run. I'm just going to go over some of the South Carolina state code definitions here, because I've heard a lot of dialogue back and forth about whether or not nicotine matters, and the state code, as I interpret it, states that it does not. So this is South Carolina Code 16-17-501, published 2024, paragraph 8B, any electronic smoking device, as defined in this section, as any substance that may be aerosoled or vaporized, whether or not the substance contains nicotine, is a tobacco product. So nicotine, yes or no, does not change it, and if it's vaporized, that does not change it. Paragraph 8B, I can tell you the code again if you'd like that. And then if you go to the next paragraph, this is under the definitions section of the code, both 8 and 9 that I'm reading here. 9 states that a tobacco retail establishment means any place of business where tobacco products are available. We just established from 8. Tobacco products include nicotine or no nicotine, and if it's vaporized, it's still a tobacco product. Any retail establishment means a place where tobacco products are available for sale to the general public. The term includes, but is not limited to, then it goes on to list various categories, showing that it doesn't matter if you call it a tobacconist or not. The term includes, but is not limited to grocery stores, tobacco products shops, kiosks, convenience stores, gasoline service stations, bars, restaurants. So whether or not you call it a retail establishment does not get around the definition provided by state code in chapter 9 of this section. Let me know if you'd like me to read that section off again. I'm sure you have in front of you the many papers that you have.
All right, do we have questions for? All right, thank you very much.
Yeah. Thank you, ladies and gentlemen, for your professionalism and all the attention you're paying to this.
All right, do we have anyone else to speak in opposition?
My name is, can you guys hear me? I feel like you can't. Okay. My name's Sarah Hires. I live at 1123 Quick Private Loop. I'm towards the front of the neighborhood and Hunt Club. I had stuff to say about having kids and how everyone that I've spoken to in the neighborhood is against this. It's not one person, it is a large amount of people. But there were a lot of back and forth that just happened that I want to make sure does not get lost in the shuffle. So first off, where was the mistake? The mistake was in using discretion. This should have gone through a public zoning appeal. It should not have been up to the discretion. The email chain makes it very clear that the planning department was searching for a workaround to allow this permit. The first permit was delayed until the second permit that removed tobacco references was made. They're the ones that are forcing a definition. The language that no tobacco will be sold on the site was clearly intended to try and subvert the intent of the restrictive covenant. The intent of the restrictive covenant is very clear, and a vape shop violates that restriction as designed. I'm not sure there can be a question as to what the intent was at this point. Vape products are tobacco products. Calling something retail does not mean that vape products are not tobacco products, and as the intent of that covenant, it is violated by issuing this. Again, I can't make this clear enough. The mistake was in using discretion. It should have gone through the public appeal process. Thank you.
I do have one question regarding the PD. Where in the PD is, since tobacconist has been removed, what specifically in the PD would disallow this use as it's written now?
Ooh, I am not one of the people who was involved in drafting
Okay.
the
And
PD.
because one of the
That kind of
things-
thing I can defer to LaDawn, who was very involved. I'm a newer resident, but my feelings on this, I think, matter.
Okay, all right, thank you very much.
Thank you. Were there other questions? Okay.
Let's get through our public testimony first, and then we'll see if we have an opportunity to come back and present again.
Sorry, I've been sitting down for so long, my knees are cracking. My name is Dan Hiddam at 1434 Teaberry Path. I just want to say thank you all for putting up with us tonight. I know there's a long line of us, and I'm the last one, so I'll try to get through this as quickly as possible. I had some prepared remarks, but as you said, please don't repeat yourself. So I will just try to get to the core of what I think a lot of us are kind of feeling is that, government is really fundamentally is to protect citizens from those that would seek to skirt, sidestep, or bend the law to their benefit. When our neighborhood initially negotiated with the developer, we made it clear what we wanted and what we did not want at the front of our neighborhood. No gas stations, we did not want liquor stores, we did not want tobacco or tobacco-like products. Now, we can go back and forth on the definition of a vape and tobacco or tobacconist, but at the time, the term that we were able to use was tobacconist, and it was used to apply to anything that resembled tobacco, tobacco-like products that we did not want sold at the front of our neighborhood. Now, as it was mentioned, that term was removed, right, from the Zoldar. And so now we are left in kind of this awkward situation of having to defend ourselves against zoning code that no longer is applicable. And as I'm a citizen, I'm not an attorney. This is my first time coming to a zoning appeals board. And so all I'm trying to say is that it's not just the letter of RPD, but it was the intent that was behind it. This neighborhood, this development, this PD was marketed as a very family-friendly development. And again, we've spelled out what our wants were. We spelled out what we did not want. And to me, to say that a vape somehow is allowed when a tobacco is not it's linguistic gymnastics. And in my opinion, that way, you could say that a wine shop, could say, well, you don't allow a liquor store. Well, guess what? I don't sell liquor. I sell wine. You should be able to kind of slide in there as well. Our developer, as I said, marketed themselves as being very family friendly, and we want to maintain that at our neighborhood. We don't have a crusade against vapes. None of us here care that vapes are a legally sold product all over Charleston, the United States. We just, as neighbors, want to be able to have a say in our neighborhood and what goes in at the front of that development. And so all we're asking you here is to honor what we came together as a community, as a neighborhood, to put into that document. Again, that term might no longer be there, tobacconist, it might be an outdated term, but there's no way for us to know that. There's no way for us to see the future and go, well, a month after this was signed, the county's gonna remove that term. Well, can you point to something in the PD that can defend yourself now? I have no idea. That's why we're coming before you to say, you know what, help us address this. Help us protect the, not just the letter, but the intent of what we wanted with those restrictions, with that PD, with that zoning. I mean,
All right, we've hit the 2-minute
minute?
time.
All right, I'm
Yeah.
sorry.
So, do we have questions? All right, thank you very much.
Thank you.
Board, I would entertain a motion for Ms. Page to come back up if there are any additional questions for the person that helped negotiate. So we have a motion, a second. All in favor, please say aye. Aye. All right, thank you. Ms. Page, you have another opportunity.
My address again.
Yes, please state your name and address for the record.
My name is LaDawn Page. My address is 886 Hunt Club Run, Charleston, South Carolina. Thank you. I think some people had some questions about whether or not uses were removed and where that came about. I have a stack of over 20 emails that transpired from May until September. If you guys would like to take more time on this case and read through all those emails, you certainly can. But I negotiated with Veris Development. This is not Adams Property Group. Adams Property Group has not once come to me to say, what would you like in your community? This was Veris Development, and they were very, very respectful of what we wanted in our community. In one of my letters to County Council, and in fact, it was a negotiation for them to get a vet shop or a veterinary clinic, is that we said, you must remove these uses from our PD. And those are outlined in some of these emails. Certainly one of mine to County Council said, as noted, the following are to be removed from the request. I think that's pretty clear that, we don't want that as a use. It said repair and maintenance, vehicle service, tobacconists, hotels, motels, retail liquor store, gas stations. Gas stations at the time was the only one that was truly written into the PD. They did specifically remove that as a use. It's pretty clear that we were saying we don't want these. So you asked if there was a list. There was a list provided to us. How could we have had a list for vape shops when it didn't, quote, exist? If Deputy Director Melisic says they're tobacconists, that's what I was going on. You can't create a new use without going through the public and the right channels to do that. And anyway, you had asked about a list. There was a list because basically the HOA came to us and said that the developer had to put a list, and in fact the county requested a list to make it more clear. And so when I saw that list, I went through each one of those uses deliberately and picked out the things that we did not want. The council was at the point of rejecting the PD amendment until they met with the community and asked us what our concerns were. So I'm certainly happy to answer any questions. Again, this is like a tennis match. There are a lot of emails that went into and a lot of thought that went into what we wanted in our community.
That was helpful. Thank you very much. Any questions? All right, thank you for that additional information.
Time. Thank you.
All right, so I think that we have gotten through everyone that was going to speak in favor of the appeal. So that would put us into the position where we're those that support county's decision in this matter. So Mr. Appel.
Ross Appel here with McCullough Kahn Law Firm and Appel, 2036 E Wall Street over in Mount Pleasant. Before I get started, as a party in interest, I'd respectfully request 10-minute opportunity to go through our position here. I think it's only fair to not be limited to 2 minutes, especially since the other side has had over an hour.
All right, give me 1 second for a procedural moment.
Sure.
So moved.
So moved. Got a second down here with Mr. Jordan. All in favor, please say aye. Raise your right hand. Aye. All right, motion
I
carries.
really appreciate that accommodation. I'm going to do my best to be brief and really try to zero in on what we're here today to talk about, and more importantly, what's not before the board. I represent the owner of the property. We are the landlord for the tenant seeking to operate in Unit 103. A little bit of sort of foundation setting here. You're the Board of Zoning Appeals, but you so rarely hear appeals, right? The Board of Zoning Appeals does three things. They hear variances, they hear special exceptions, and they hear appeals when there's been a claim that the zoning administrator or another staff member has erred in the interpretation of the zoning ordinance in a particular case. So the BZA really is sitting as a quasi-judicial body at this point. And the sole question before the board this evening is, what does tobacconist mean? And more importantly, what does it not mean? And we're here to respectfully submit that the county zoning department, not the planning commission. There was talk earlier about a planning commission. Planning commission has had nothing to do with this. This is a situation where our tenant went in for a zoning application for a use allowed by right under the zoning that exists at the time. It's not a public process. Joel and his staff every day speak with developers, industries, businesses about the zoning ordinance. What use is allowed where? Hey, I'd like to do X over in this part of the county. Am I allowed? They are called upon to make administrative interpretations and judgments every day. It's not some behind closed doors nefarious deal. It's the ordinary day-to-day practice of what it is to be a zoning administrator. Here, the zoning administrator and his staff, in major consultation with county legal, after an extended period of time and back and forth with communication with the applicant, which is nothing wrong with that, rendered a zoning decision that the neighborhood does not like. They took an appeal, and that's why we're here today. Brief background on the facts. Initially, a zoning permit was issued for a tobacco and a vape store. That was back in November of 2024. Shortly thereafter, there were some concerns raised by the county staff to me, as the attorney for the property owner, that that permit may have been issued in error. Why was it purportedly issued in error? It has to do with this whole removal of tobacconists from the list of permitted uses in the Hunt Club PD amendment. Now, we went back and forth over whether or not county council actually removed tobacconists from the list of uses. We think they didn't actually effectuate this negotiation that you've heard about today. It's one thing for a developer, which by the way is not my client. I don't represent Ferris. I represent the current owner of the shopping center fronting Bees Ferry. Zoning ordinances only become effective when they're adopted by county council. When they've gone to planning commission for recommendation and they go to county council for approval. So the only thing that's relevant here is what county council ultimately did. Rather than fight with the county over, was tobacconist taken out, was it not, we said we'll agree with the county in order to be good neighbors. What does that mean? We will voluntarily take tobacco sales out of our business model. We will revise our letter of intent submitted to the county to take out any reference to tobacco retail sales, tobacco use on the premises, and limit the use that's being permitted as a vape store only. There's been talk about how, well, we're just making promises and we're gonna break promises. Let me tell you one thing about Charleston County. When you stray outside of what's in the letter of intent accompanying your zoning permit, you're gonna get a call from these guys. I've gotten many of them, my clients have gotten many of them over the years. You're held to what you say you're gonna do and what your limitations that we've self-imposed are. So there's no question that the permit that was ultimately issued in this case is limited to vape only, has no reference to tobacco, and in fact places an obligation on us not to have any tobacco. The tenant in this situation is an immigrant. He's a small business owner. My client's a small business owner. They entered into a commercial lease for this use at 103, Unit 103 over in the shopping center over there. He was issued a permit in November. It's now June. When they filed their appeal in March, it triggered an automatic stay under state law, meaning we can't do upfits, we can't move in, we can't conduct business, we can't do anything. Because in Charleston County, it takes 2 months to get on an agenda to come see you guys. And I'm not complaining about that. That's the process that we have, and that's the process that we've had to abide by. But I just want to make sure the board is clear that this has caused significant hardship for the tenant. It's caused significant hardship for my client, that they have been stuck in mud, even though they've complied, even though Joel Evans agrees with us, even though county legal agrees with us. So that's what we're here to do today. We're focusing on an appeal of a zoning permit, which we could have been the one appealing this whole tobacconist issue and demanding you better allow us to use tobacco at this store. We had arguments for that. I was actually backed down from doing that by the tenant. He said he wants to be a good neighbor. He wants to be in business. And that's what we're trying to do here today.
Mr. Appel.
Yes, sir.
It has been 10 minutes.
Oh, is it really?
Yes.
Can I ask for a brief period?
You have... Oh.
Oh, great.
My mistake. I wrote down the wrong time. Go for
All
it.
right. I'm going to be brief on the legal issues here. When there are disputes over the interpretation of a zoning ordinance, some very specific legal principles apply. Very specific legal principles. The most important is South Carolina case law that requires zoning ordinances be strictly construed in favor of the free exercise of property for the benefit of the property owner. Okay, and that comes from the Helicopter Solutions, Inc. versus Hine case. This case law is all set forth in the letter that I wrote and submitted, which is included in your packet. The case law says, quote, "It is a well-founded principle of law that, quote, statutes or ordinances in derogation of the natural rights of persons over their property are to be strictly construed as they are in derogation of the common law right to use private property so as to realize its highest utility and should not be implicitly extended to cases not clearly within their scope and purpose." That's what the appellant is trying to do here. Another issue is, and this is a question that Mr. Truslow asked, what is the standard of review? There's a case for that. In historic Charleston Foundation versus Krawcheck, and that's Lenny Krawcheck, by the way. I served with him on the BZA for years. He was appointed by Mayor Gilliard. He served on the BZA longer than Joe Riley was mayor. Little BZA trivia. South Carolina's appellate courts have long supported extending, quote, "great deference to the decisions of those charged with interpreting and applying local zoning ordinances." Joel Evans is an unbelievably well-regarded, experienced, professional zoning administrator. This decision was not made in haste. This decision was made after massive internal, independent research. Joel Evans is not opposed to telling me no, let me tell you. It's happened before, and it will happen in the future. This time, we come arm in arm together with Charleston County in close collaboration with their attorney. So that's the test that we're here to talk about today. It's not what was intended, what the neighborhood thought. It's a strict application of the zoning ordinance. Rules, if there's ambiguity, we don't think there's any ambiguity, but if there is ambiguity, we get the benefit of the doubt. Joel gets great deference. Tobacconist is not defined in the PUD. It was never defined in the Zelder. But the Zelder has an internal mechanism that guides Joel's decision-making when it comes to interpreting words that are not defined. Where do you go? You go to the dictionary, the Merriam-Webster's Collegiate 11th edition. And when you look at the dictionary, the word tobacconist is in there, and it says, quote, "dealer in tobacco, especially at retail." We're not selling tobacco. Case closed. They are making much of this state statute that the General Assembly adopted in 2023, the Omnibus Tobacco Enforcement Act of 2023, which, by the way, strictly prohibits sales to minors of tobacco and vape products, which our tenant will comply with, of course. So this gets to the question and the concerns raised by the community. Zoning is important, but it's not the only source of regulation. We're going to be highly regulated, and we're going to be a family-friendly, good member of the community. But the very statute that they rely on to say, oh, tobacco and vape are the same thing, look what the General Assembly did. Section 4 of the Act says, quote, "nothing in this Act shall be construed to interfere with a political subdivision's authority under Chapter 29, Title 6, including without limitation with respect to land use regulation, land development regulation, zoning or permitting," end quote. The Act is irrelevant for these purposes here tonight. Irrelevant. Irrelevant. What's relevant is the dictionary definition of tobacconist.
All right.
Dealer in tobacco and retail.
We are at 10 minutes now.
Okay, I am happy to answer any questions. There's been a lot that's put on the table. I'll just close by saying county got it right. Small business. We respect the neighborhood. LaDon is my dog's vet. She's a wonderful, wonderful person. I love LaDon. But here today, we are here on a narrow focus, a legal matter, a quasi-judicial situation, and respectfully request y'all uphold the staff's interpretation.
All right. Mr. Neal?
Yeah, just real quickly. So is it your opinion that the permit that was approved, I'm not going to say the second permit, but the last one that had a reference to no tobacco, basically a clear statement that said no tobacco would be sold. Is it your opinion that that strengthens the argument of the zoning administrator of stating that that's what we don't want here? Because it sounds like the appellate is saying the exact opposite.
Yeah.
They're saying that, well, why did he put that in there? Well, if they weren't going to be, if vape shops weren't tobacco, why would he even reference to that? Is it not an argument from the zoning administrator to say that, to be very clear, because this is a gray area, so that there is no doubt? I mean, is that something that the zoning administrator would do on a normal basis? Being, if something is unclear, let me really line it out. Do you have any experience with that? Or?
Yeah, absolutely. Again, this is a very common thing you see in zoning. By the tenant voluntarily agreeing to abandon tobacco sales as part of his business, he made the staff's job easier in issuing a permit. The first permit, we could have stood by. Tobacco plus vape, right? Because there's all kinds of arguments that tobacco is still allowed. We jettisoned that to be good neighbors. And we jettisoned that to make it easier for staff to make a call. In fact, there was an initial idea to maybe allow tobacco as an accessory use. We got rid of all that. So by changing the business model voluntarily, we actually made the use fit more neatly into the list of allowed uses. Because if we're not a tobacconist, we're just a general retail sales.
And that gives argument to why the zoning administrator would put that verbiage or language in the permit.
Oh, exactly, but I would clarify. I wrote the letter of intent. Okay. We're the ones that pared back and narrowed what we were asking for. They reviewed it and approved it. So it wasn't Joel putting his thing. Staff, it's not staff's decision to legislate or declare winners and losers. Staff's sole job is to interpret the zoning ordinance as written. It's our ability as an applicant to submit an application for something and take a position that we fit within the box. They call balls and strikes based on their knowledge of the zoning, their expertise, their professionalism, and that's what they did in this case.
Thank you. I'm good, Mr. Chair.
All right, thank you, Mr. Neal. Any other questions? Mr. Truesdale?
I had one, thank you for your presentation. I had a threshold question. Is it your contention that nicotine is not considered a component of tobacco? Just a yes or no?
I would be, no, nicotine is definitely in tobacco. But just because you sell a product with nicotine doesn't make the product you're selling tobacco. Does that make sense? So clearly, nicotine is in tobacco. It's a naturally occurring chemical, but as was pointed out by Mr. Seidel earlier, there are synthetic versions of nicotine, and that's what's included in vapes.
In this vape shop, are they selling the synthetic nicotine, or are they selling the tobacco nicotine?
So what I will say to that is nothing that we are selling under the amended zoning permit is tobacco. So I would go a step further and to say, even if you were to extract nicotine from tobacco and put it in a vape, that's not tobacco. That's a vape.
Any other questions?
No.
Tobacco is a leaf. It's a plant. So like in a cigarette, that stuff, that dried up stuff in a cigarette, that's tobacco. Or chewing tobacco in a you know, like a tin or whatever. Or how, I don't smoke or vape. My wife would kill me if I did any of that stuff. But yeah, all I can tell you is we're not selling tobacco.
Any other questions?
Yes, sir.
Mr. Jordan.
Trying to think this one out. So if vape does not have tobacco in it, then what is it?
My understanding is vapes are comprised of chemical synthetic components that are liquid in nature.
And what are they made out of?
All kinds of chemicals, extracts from things, synthetic compounds. But at the end of the day, the retail products that we are going to sell under the permit the county issued is not tobacco under any definition of the term tobacco.
So tobacco is not part of it.
100% not part of it. And we've committed to that. I mean, those documents on the screen hold us to that. There will never be a cigarette sold in here. There will never be a cigar sold. There'll never be dip. Is that something still people do? Or the little Zins? Or what was Bobby Kennedy doing during his hearing? Like Zins, I think. I don't know if that's tobacco, but.
So vape has no tobacco in it.
Correct.
Thank you.
All right, Ms. Smith.
So the disallowed uses in the plan development were repair and maintenance services, automotive oil change and lubrication shops and car washes, and gas stations. So the common factor for those would be auto-centric development. So most of the disallowed uses were to try to maintain more walkable development style, not to restrict what kind of shops people could open. Is that correct? Do you know?
I mean, it certainly seems as though that was a major concern of the neighborhood in fashioning some of these PUD amendments, you know, very highly auto-related uses. But I can't really speak to intent, and, you know, as the quasi-judicial body here reviewing the zoning administrator's interpretation, you know, y'all are held to interpreting the ordinance as written. And tobacconist is not allowed. Retail general sales are. There's a question as to whether or not we're a tobacconist or not. I'll grant for the moment, I think it's clear that we're not a tobacconist, but let's say there's arguments on both sides. Case law says we win. Helicopter solution case says we win because the tie goes to the property owner because it's the government's burden and obligation to be exacting and clear when they're regulating land use. And other jurisdictions around the state have. And we went through this whole exercise with the staff. Like there's jurisdictions all over the state that call out specifically vape shops and things of that nature. That did not happen here. That's what should have happened here in order for vape shops to be prohibited.
Mr. Appel?
Yes, sir.
Thank you very much for your time.
All right,
don't
I
have any
appreciate it,
further
y'all.
questions.
May I ask one more question?
Sorry, I
I'm
was
just trying
premature.
to understand, going through these definitions, do you
Yeah.
contend that nicotine is a derivative of tobacco or a component of tobacco? What is your
Oh, I think
position?
those are biological facts.
What is your position? Is it a derivative or is it a component?
Well, it's definitely a component. I mean, there's naturally occurring nicotine in tobacco.
All right.
But, and there's a lot of types of vapes that have no nicotine in it. So, I mean, there's, the proper way to prohibit vape shops is to say no vape shops. That never happened.
Okay, so what you could have done, I suppose, is restrict this further and say, well, we're going to have a vape shop, but it won't contain any nicotine. Is that correct?
I suppose that's that would have been possible, but I would submit that we were under no obligation to do that in order to fall outside the definition of tobacconist, fall within the broad definition of retail sales, especially under the statutory interpretation principles that I mentioned earlier.
Mr. Chairman?
Mr. Sudell?
So,
Yes, sir.
That was an interesting question, I thought. You excluded tobacco.
Right.
But why not exclude any products containing nicotine? Because you still have a vape, right? But actually, it seems to me that what's being sold is the effects of tobacco and the effects of vaporing, which are similar, and therefore the appeal at retail. And we've heard testimony from, there's a fairly clear understanding what the intent was of the residence agreement and plan development with the developer. These are types of activities and shops, retail, whatever you want to call them, we don't want in our community. But it would seem the logical extension of this is vaping is not tobacco and not that. Eliminate the habit-forming part of it, which is the nicotine, and say no tobacco nor no products, no vape products with nicotine. And that would satisfy probably the community and allow you still open a vape shop.
I'm going to jump in here for a second because we're wandering well outside where we're supposed to be with this particular hearing, which the point here is whether or not the zoning administrator made a mistake in issuing the permit for this. And we're now way down in the weeds of whether or not nicotine and tobacco are one and the same.
No, I guess maybe my question's for staff, so I'll hold my question about plan development and the decision-making process.
All right. One thing I will remind everyone is that in Exhibit 1 of our documents, the PD is there, and it does list the allowed uses and what was specifically prohibited at that time, and that would be a great point of reference for us as we have our discussion, make a decision. So,
Thank
Mr.
you,
Neal.
Mr. Chair. So I started my first question with the presentation by the appellate with my question was, where is the mistake? And I believe Mr. Appel has, and I want to make sure I'm clear on it, what I heard, is he has labeled where the mistake is. Because, again, what the chair said, the review of the vape, the review of the tobacco, the review of the tobacconist, the question we have in front of us, I believe, that we have to come to a decision on is whether the zoning administrator erred, made a mistake, and we should correct that or we should go with it. Everything else, all of the things of vaping and tobacco are all aside. Even the intent. I applaud the community group for taking an active role and being aggressive, that you don't want car shops and you don't want this and you want that. I believe the mistake was by either the use table initially from the county or by the ordinance that was written or by the PD when it was written, that there wasn't enough detail in it. But if I'm hearing Mr. Appel correctly, and please respond, the remedy is to get the ordinances correct, get the PD correct, moving forward. A remedy would not be overturning this, the zoning administrator's decision, because then you would open up more Pandora's box. And you said there's case law out there for basically when it's a tie, you go with the landowner. So I just wanted to make sure I heard that correctly.
Yeah, I think we've had a long hearing tonight, heard from a lot of different perspectives on this, but yeah, you just hit the nail on the head. We would submit no mistake was made in this case. To the extent something went wrong here from the perspective of the community, it was a political breakdown, not a staff error, which is the sole purpose of the BZA's appellate review. Did Joel Evans and his team, in consultation with county legal, make a mistake when they permitted a vape-only shop? Is a vape-only shop a tobacconist? We respectfully submit the answer to that question is no. We agree with the county. The county did not make this decision lightly. They studied it. They talked to other jurisdictions. They conducted an enormous amount of independent research. They made a determination. The determination is supported by the facts in the record. The determination is supported by South Carolina law. And we would respectfully request that you guys affirm the county staff in their well-reasoned, well-supported decision.
I'm done.
All right, Mr. Appel, thank you very much
All right.
for your presentation. Is there anyone else here to speak in favor of the county's decision? I did not think so. All right, so that.
Mr. Jordan.
I'll say mine to our debate.
Okay, all right. What was the next step in the process, Mrs. Working?
I put it up on the screen.
Oh.
Sorry, I had to stand up.
All right, yeah,
Rebuttal.
I get it. All right, So the county has a chance, no, the appellate now has a chance to rebut. Thank you.
Thank you again, everyone, for your time this evening. As an initial matter, I take issue with the suggestion that this is in some way discriminatory. I graduated from Georgetown Law School, which is one of the most diverse law schools in the country, and this is not about immigrant status. This is not about trying to penalize anybody financially. And in fact, had the normal application process taken place, it took the Planning Commission from November through March to determine that they had made a mistake in issuing that first permit. And so that's the normal course of the nature of what this is, and that's not something that can be held against us as appellants in this case. If this workaround, I'm calling it a workaround because I see emails in our FOIA response that show that the applicant believes that incidental amounts of tobacco should be able to be sold in the store, notwithstanding their stated intent that they will sell no tobacco. I feel that that's disingenuous, and frankly, they're creating a loophole. And if they wanted to create a new use called vape shop in the plan development, they should have filed for an amendment of the plan development and gone through the process, just as the developer did in 2021. I also would like to point out two other issues. I raised them earlier, but I just want to remind you that both the first and the second applicant are on file with the South Carolina Department of Revenue as tobacco retailers. And finally, under Rule 11, South Carolina Rules of Civil Procedure, as a plaintiff's attorney, I have to investigate a case before I take it. And I can tell you that the applicant has many vape shops, tobacco shops, whatever you want to call them, combination. And that's why the Chillax Tobacco and Vapor 3 LLC is because they've got Chillax Tobacco and Vapors 1, 2, 3, and so on and so forth. Again, this is not about financially imposing any intentional consequential damage on the applicant. This is just the nature of zoning and the time it takes. Finally, I will say, and nobody has raised this so far this evening, is I visited the neighborhood over Easter weekend, and this PD, as I'm reading it, says, there's a courtly entrance area from Bees Ferry Road, beautifully landscaped, leading through the commercial properties to the residential semi-private neighborhood. The Hunt Club recreational facility will allow residents joyful access to relaxation, group gatherings in a natural setting. This shopping center faces the neighborhood, so when you leave the neighborhood, there's no buffer of trees or anything of that kind to hide what will be the signage, the neon lights, and what have you. They are registered with SCDOR as a tobacco retailer. Thank you for your time.
Do we have additional questions? All right, thank you very much.
Thank you.
All right, so at this point, we will close this case to the public, and I'm sure that there will be, well, are there any questions for staff before we move toward a motion and discussion and all that fun stuff? Yep. Mr. Sudell.
I'm sorry to understand the process when there's an approval. If there's a PD, is it similar to like an HOA? The HOA can be more strict than the county, and we honor the HOA, or is in the PD situation, that's not the same situation?
They're not the same.
Okay.
A PD is the zoning of the property.
Right.
And the HOA is the private covenants and restrictions if they choose to
Okay.
have them.
So, but is what the zoning of the PD is controlling and decisions?
From our perspective,
From your
from the county's
perspective.
perspective,
Okay.
yes.
All right, thank you.
Mr. Neal?
Yeah, I heard in the would you stay there for a second? I think you would help clear up. I think I heard in the appellate's rebuttal remarks, she mentioned that the planning commission had issued the permit, and that's not possible. That's county staff.
Correct.
Right? So the process had nothing to do with, the planning commission makes a recommendation on the PD.
Correct.
The county council votes on the PD.
Correct.
And any amendments on it. The planning commission might take up might take up public comment and hear things, and they'll make a recommendation, but county council ultimately passes the ordinance. So
That's correct.
she erred in that statement of saying that the planning commission issued the permit, because the county
Right.
staff would issue the permit, correct?
Yep. Planning Commission recommends, county council's the policy, the final decision-making body. Staff implements what the policymakers approve.
Thank you. Thank you, Mr. Chair.
Ms. Brooks, I had a question for you a long time ago. Did you manage to dig up an answer?
Okay, so let me make sure I have because I found some information, make sure I have it right. Some vape type shops, permit issued since the ordinance.
Yeah, that would
and
fall under other.
incorporated it into retail sales.
Yes.
Yeah. So I'm sure there are several more probably than what I found in this time that I've had to look through these. But the ones so far I've found since the amendment in 2021 would include Harbor Smoke Shop at 816 St. Andrews. That was issued in February of 2024. 540 Smoke and Vapor, 2280 Savannah Highway in December of 2022. M&M Vape Shop at 2578 Ashley River Road, issued in March of 2024. Those would have been captured, vape, under the retail sales, whether or not they had tobacco or not, would all be incorporated into that retail sales category. So those are some examples of ones that we have issued since that amendment in 2021.
Okay, and noting that this particular application's not underneath that same zoning ordinance because it's under the PD, but the decision process is the same, right? That might be, somebody else within the county might answer that. Because that would have been under Zeldar, not underneath this particular PD. Those that you mentioned, yeah.
Right.
Yeah. Ms. Smith.
I can't hear. Can you talk into the microphone? Can't hear you.
I was just saying, I think maybe there was some confusion about your question and the answer to it. I know we're closed now to the public, but like everyone was like, that's not correct. So maybe we could recap what y'all were just discussing.
Yeah, well, the comment that I heard from the appellate in her rebuttal was she stated that the planning commission issued the permit. That's what she said. Unless I completely misheard something, that's what was said. And I don't think it really makes an issue because she just made a mistake in her comment. But if Chairman wants to bring her back up, or I'll defer.
I think there was a mistake.
She said the planning commission made a mistake between November to March. That's what I wrote down.
Right, well, the public comment section is closed.
I think she meant the planning department made
Right.
a mistake.
Right.
But she said planning commission.
It's not the first time that someone has said that, by
Right.
the way. This is not, that's not an uncommon
Yeah, that's
statement.
understandable, yeah. Thank you.
All right.
Did that make sense?
Yeah, yeah, yeah. I
Yeah.
just wanted to make sure that was clear.
Yeah, thank you.
All right. All right, any other questions for staff before we entertain a motion? Mr. Brown?
So I'm looking at the PD, and I have no legal background whatsoever, so forgive my ignorance if there is some here, but when a permit comes in and they're asking for a use that is not specifically specified in this list of allowed uses, for instance, I'm not, on my quick peruse of this over several times, I haven't seen anything specifically stating anything about tobacco. Is it, I see disallowed uses or prohibited uses, and then I see a long list of retail sales. What's the, if it can be quickly explained, how does tobacco get lumped in or not lumped in, or allowed or not allowed after this process that these folks went through to get this amended? What?
So if you're looking in that PD document, there's a shorter list of allowed uses at the front, and then you scroll further back, and there's a whole section about parcel 34. And that's what the amendment was about, was that commercial piece of it. And so you're right, you don't see tobacconists in that list, because when the applicant originally came in to amend the PD, they had that list of uses, but it also included all those things that were talked about that ended up being removed. It also included tobacconists, because that was a use in our use table at the time. Car-centric service type things, gas stations and things like that. So, as you've heard, the community worked with the applicant. Staff wasn't involved in that process, other than to process the PD application, and they came back and said, we're removing this handful of uses, the tobacconists and the service station and those types of uses. So those things just came out of that list. It wasn't like they were put on a separate list of, and these are prohibited. They just came out of the allowed use list. But retail sales and services are still in there. So that's why you don't see tobacconists in there. It took us some time to go back and research that had happened, and then to know that handful of uses are really prohibited, even though they aren't stated in the PD that way. But we do have documentation of that, and I think that may actually be in your packet, the letter from the developer regarding that.
Okay, so I've kind of flipped through here quickly. There's a long list of include the following allowed uses in this revised, new adopted PD, right? And it is allowing under retail sales tobacconist?
Well, so as you heard the timeline of things, this plan development was adopted in September of 2021. And so tobacconists had been in there.
Okay.
But it got removed. It's not in a prohibited list, but, we understand the intent was that tobacconists, hotel, motel, car services, those types of things are not allowed in that plan development. What happened in October, after about a 3-year period, we had several uses in our use table that were combined, not just into retail sales, but into other things. It was part of a complete overhaul. There were hundreds of amendments that happened to our ordinance. It just happened to be that was one of them, that tobacconists became part of retail sales, when that 3 or 4 year process culminated with council's final adoption in October of 2021. But the PD still stood on its own with those 5 or 6 uses that have been removed from that list of prohibited or of allowed uses. Does that make sense?
Sort of. So does removing it from the list of allowed uses does not automatically make it?
It means it's not allowed.
It means it's not allowed.
Correct.
It's not on the list.
Right.
It can't be done.
Correct.
Okay.
Yep.
Thank you.
All right, guys, it is time for us to make a motion in regards to this case. And after said motion, we can have some, I'm sure there'll be ample discussion.
No, I'm sorry, can I add one more question?
As long as it's a matter of process, because everybody's already provided testimony in this case.
I didn't understand that. I think you said if it's not on the list, then it can't be done,
Correct.
right?
Well, yeah, retail sales. If it's something that, the category retail sales includes a lot of stuff. that
Okay.
aren't going to be specifically listed. We can't list out every single type of retail sales out there.
I see, so that's the gray area there. Vaping falls under retail sales, and it's not listed, but it's interpreted as a retail. Okay.
All right, board. We have work to do now.
Just for a point of order, Mr. Chair?
Sure.
So the appellate, the appeal here is to overturn. So a motion in favor, would the lawyer help us here? There you go.
Yeah, so the director has made a decision. That decision has been appealed by the appellant. They want you to overturn the director's decision. So you're either going to uphold the decision or you're going to overturn it.
To overturn the decision will require a 2/3 vote.
Correct.
All right.
I would think
So
we would have three choices. One would be to sustain the decision. The second one would be to reverse. The third would be to reverse and remand, which it would result in some delay for the respondent, but they could make a better record than we have before us, perhaps.
I am going
Aren't
to
those our
defer
three
to our
options?
attorney. I do not think by statute we would
You can
have.
uphold the decision or you can turn over the decision, and then they'll decide from there what they want to do. This is not remanding. No.
Courts reverse and remand all the time.
I know, but you would.
But we don't have a,
You're not if you uphold the decision, appellants can appeal. If you overturn the decision, county can appeal. That's the process.
We're not the final say.
right.
Okay.
All right, so somebody needs to make a motion.
I'd like to make a motion to uphold the decision.
Uphold the decision by staff.
Second.
Yes.
All right, so we have a motion that's been made by Ms. Smith and seconded by.
You need to clarify, if you're upholding the decision, you need to make a determination that the director did not abuse his discretion in making the decision.
I'd like to make a motion to uphold the decision and confirm that the director did not abuse his discretion in making the decision.
Second.
So the motion's been made and seconded. Is there any discussion?
Let's see,
Mr. Jordan?
Well, you're asking about the Pandora box. I'm certainly not a lawyer. Don't pretend to be one. I operate on what I hear and common sense. And I'm sure that our zoning people know what they're doing. I have a lot of respect for that. But I just have a problem that they went ahead and made a decision and issued a permit to still not being able to make a decision what's right or wrong, if I'm interpreting that right. I mean, what is the neighborhood supposed to think? What is the person trying to get the permit supposed to think? I think that was a fault. I could be wrong legally. Like I said, they know their procedures. I don't really know much about them. But I got a real issue with that.
Well,
And I wish you'd think about that.
Well, Mr. Jordan, what I would say to that is there are a lot of decisions that are within the authority of the director. Those decisions that are not come before the board. So making that decision was not unusual.
Okay. And the second thing is, I wasn't quick enough on this one, I don't think, but did I hear the attorney for the neighborhood say that this applicant had other locations? Did I hear that?
Yes, but that's not before the board.
This isn't, but I'm leading up to something.
Okay. Yes, sir.
All I'm trying to say is I wish I would have thought quick enough to ask her, is he currently operating in the other locations that do not have tobacco?
I don't think that matters.
All right. Any response from Mr. Jordan or other discussion?
Well, I have several comments, but the first is I don't doubt for a second that the decision of staff was well-intended, but I'm concerned that it perhaps misconstrues a modern definition of tobacco quite candidly, and I appreciate the candor. Mr. Appel, I asked whether an alcohol, in this case nicotine, an alkaloid substance, is a derivative or a component of tobacco. He was very straightforward, answered my question directly as I have always come to expect of him, and said it was a component of tobacco. Yeah, I'm going to vote to, if I'm forced to vote today, I'm going to vote to reverse the decision that was made. I don't think we have time right now to discuss all the facts and law that is applicable, but it's going to be necessary to give it more thought. It's going to be necessary to, we're going to have to conflate law with facts in this case. I assume we're almost hearing this case de novo. We've got a fact that nicotine is a derivative, or it's a component of tobacco. We have e-cigarettes deliver nicotine, vape shops deliver nicotine. I think we all know how nicotine is extracted from tobacco. All you do is you dry your leaves out, you masticate them, you filter them out, and then you enhance the nicotine so that it can be delivered through another form. Yeah, I could go on and on, but those are some of the facts that I would consider in making a decision.
And you, as every individual member of the board, should decide the reasons within the confines of the statute of whether or not the administrator was correct or incorrect. But questions about whether or not something's nicotine, and that's really not before the board. So you should vote based on the facts, based on whether or not you think the facts lead up to the director was incorrect in the decision that he made. That's all.
I understand.
So where I stand on this, I mean, this is, I don't know if anybody, if they were asked whether or not they support a vape shop, would sit here and say, yes, we want vape shops on every corner. That's not a matter, would not be a very long debate here. But the county is faced with a very difficult task of making a lot of zoning-related decisions every single day, looking at the ordinance that they have in front of them or looking at the PD that they have in front of them. And at this point, what we do have is testimony from the county that in the way the county regulates vape shops in every other zoning district right now is under the category of other retail. It's pretty plain to the county with how they have applied that since 2021 when tobacconist was removed from Zeldar. Now, it may have been something that has come into a state of vogue for vape shops to spring up since 2021 that was never really considered as part of the PD, and that's quite frankly unfortunate more so than anything else, and would speak volumes toward updating the PD more than it would pointing a finger at zoning staff or whether or not they made a mistake or not. So, I mean, I am inclined to decide with staff here that they did not make a decision. I do believe it's unfortunate. I don't think anything here is intentional or nefarious. It just is what it is. Play it as a lie, as my colleague would say. So, Mr. Neal.
Yeah, I don't want the community especially to think that I'm sitting here in favor of vape shops, because I'm not. The decision that's in front of the Board of Zoning Appeals, one, is a very difficult one tonight because it's got a lot of emotion. It's gotten people out here. But the facts that we have to make a decision on, that my one vote has to make a decision on, is whether the zoning administrator made an error or just made the wrong call. And I don't believe in any question I've asked tonight that I've gotten an answer that the zoning administrator made a mistake. Is it not the intent of what the community wanted? 100%. I agree with you. I think there were some discussions back and forth. There were some very smart people that were negotiating with the developer that basically didn't want some type of tobacco sales. They're not going to get tobacco sales. Is that going to stop another vape shop or something else? Hopefully, county council will sit and learn from this issue and be more detailed in their ordinances. But the fact that we have to that the zoning administrator has to make interpretations, and he just has to testify to that. They don't pass ordinances. County council passes ordinances. They interpret that information and are held to a standard to enforce that. And that's what I believe has happened here. Is it a bad ordinance? Is there not enough detail in it? Yeah, it's pretty bad, and it needs to be changed. But for this case, I don't believe it should be overturned. And the other point that I want to make is we keep coming back to an issue of is this current retailer selling things at his other shops, and are they registered in different places for all this stuff? I don't care if he's got 100 stores up in Columbia. That's every one of them sells tobacco. That doesn't influence my decision on this case. And this case is about the zoning administrator and did he make a mistake? And my vote's going to be for he did not make a mistake. Thank you, Mr. Chair, for the time.
All right, thank you, Mr. Neal. Is there any other discussion? Mr. Seidel?
I don't think that he made a mistake in that he has to go to the dictionary to what the definition of tobacco is. So I think all the procedures are followed, and based on that, the decision was the correct one. But I think it's also common sense, common knowledge, that the definition of a tobacconist is evolving, and has evolved significantly over the last several years. And people associate vape shops with tobacco or the effects that you get from something that's not tobacco that is seen as somehow better than tobacco. So I think if he followed the procedures, he followed it correctly. But I think that discretion in this sense would have indicated that this definition no longer is constrained to the tobacco product as it would seem.
Even in doing that, if the zoning administrator made a decision that's inconsistent with other decisions, then he still opens himself up to an appeal, and it would come before this body, and we would have to decide whether or not he had erred.
If he had made a decision to approve
Or if he had made a decision to deny.
Oh, that's absolutely true, right. So, but it seems that the whole thing turns on what is the tobacco, what's a tobaccoist, right? And I think that...
That's not what we're charged with determining here, though, right?
Right. So...
I'm on the same
I guess
boat
I'm
as
on
you.
the question for me is there where does discretion fall? How much discretion is there? Can you look at
That is why we have ordinances, though, and that's why the Board of Zoning Appeals even exist. So the discretion is limited so that the property owner knows what their rights are for using their particular piece of property. And if they follow what is prescribed in the ordinance, then it's a by right use, and they're allowed to do what is described in the ordinance. If it strays from that, if there's a hardship, then it comes here, and we hear the matter then. I mean, that discretion is what leads to, I would say, a lot of lawsuits when it comes to how somebody uses a piece of property. If the county, if any zoning staff is inconsistent with the way they apply that discretion. Mr. Truslow.
Well, I'm just thinking, but it seems, which may be dangerous, but I'm thinking as one of the components of what we're dealing with, aren't we supposed to be thinking about safeguarding the public? Shouldn't we be more?
Our
sure?
call
Can we
today is to
factor that
determine
in?
whether or not the zoning administrator made a mistake in application in their process of issuing the permit.
Well, should he?
We don't have the 7 criteria.
Should he factor in an intent to safeguard the public?
If that is written into Zeldar specifically as their decision-making criteria, then it would be factored in, yes. But this is about whether or not the use that they authorized, whether or not he made a mistake in allowing that permit to be issued. All right. Let's take this to vote, shall we?
Can we state the motion?
The motion on the floor is to support the administrator's decision that he did proper practice discretion in issuance of the permit. Is that correct? Did I get that right, Mrs. Smith? Yeah, thank you.
Mr.
All
Chair,
right.
can there be a roll call on that?
I don't think we need a roll call.
Keep your
Let's-
hands up.
Yeah.
Longer than.
All those in favor, please raise your right hand and say aye.
Oh, okay.
You have everybody? Five. All those opposed? All right, so the motion carries. We needed a two-third vote of the members present to overturn the order that was issued. So we do appreciate your time tonight. We understand your concerns about this. And I would assume you guys, I guess at this point, the county will notify you of the decision within 10 working days. And that decision will give you 30 days from the date of this decision to move forward with the appeals process. Thank you very much.
Mr. Chairman, I have a question. Are we the ones that are charged with now having, writing up specifically the reasons why this,
No, the
No.
answer is no. Staff.
staff writes it up?
Yes.
It would be a part of the minutes that we then approve at our next board meeting. That's the only write-up that occurs, and it states whether or not we approved or disapproved. Now, all of these meetings are recorded, and they can be transcribed for future use later on.
There will be an order prepared by staff and your attorney,
All right.
so, with findings of fact. And that will be mailed, and within 10 days, it will be mailed in 10 days. And then from the date it's mailed, they have 30 days to appeal.
The appeal
To
is to
circuit
circuit
court.
court.
All right. Ms. Working, can we take a 10-minute break before we
Yes.
proceed with the next case? All right, we're in recess until 7:30. Thank you.
Thank you, girl.
It was 5-3 to uphold. All right, we are reconvening this the Board of Zoning Appeals, 7:32. Mr. Ziegler, you have case number BZA 0425000859.
Yes, in the case BZA 04-25-00858, the applicant and property owner Benjamin Farmery of Madison Lansdowne LLC is requesting a special exception to establish a short-term rental property, extended home rental in the Natural Resource Management NR zoning district at 2301 Captain John Hutt Road, TMS number 57113000001 on Goat Island in Charleston County. The subject property and surrounding properties are located in the Natural Resource Management NR zoning district. The property contains a single-family residence that was constructed in 1994 per Charleston County records. There is also a seawall and dock that were rebuilt in 2023 per Charleston County records. The applicant would like to rent 4 bedrooms. There are no cars on Goat Island. Parking will be provided at the property owner's office in the Wild Dunes Yacht Harbor parking lot off of 41st Avenue near the Isle of Palms Marina. The maximum number of guests allowed will be 8. The property is not owner occupied, therefore the property is not eligible for a limited home rental. This is the zoning map, and here are the zoning ordinance requirements. Next, we have the 300-foot radius map and a few aerial photos of the property. We posted the property on May 15th, 2025. And here are some more photos of the subject property and some surrounding properties. This is the site plan, tenant notice, and plat. Regarding the approval criteria, we stated that it may meet 1, 2, and 3. The Board of Zoning Appeals may approve with conditions, or deny the request based on the BZA's findings of fact, unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the application, the board should consider the following conditions recommended by staff. 1, prior to zoning permit approval, the applicant shall complete the short-term rental property limited site plan review process. 2, the use shall comply with all requirements of Article 6.8. 3, this property shall not be used as a short-term rental for more than 144 days in aggregate during any calendar year. 4, the property owner shall be responsible for ensuring that tenants comply with the Charleston County noise ordinance. And we did not receive any public comments regarding this application. Are there any questions?
All right, do we have any questions for Mr. Ziegler? Mr. Truslow, go.
How many parking spaces are required under our ordinance?
It's 2 per rented bedroom, or 1 per rented bedroom plus 2, but on Goat Island, 0, since there are no cars.
So what they're going to have to do is park somewhere on the Isle of Palms,
Correct.
presumably.
He owns an office in the Isle of Palms Marina where guests can park.
I understand. In the yacht harbor, it's Wild Dunes Yacht Harbor, what do the bylaws provide for commercial use of the boat slips or that parking area?
I'm not entirely sure. That'd be a question for the applicant.
Well, so how many cars would they need?
Is not applicable.
Goat Island doesn't have any provision for cars.
No, sir.
They're going to have to park somewhere, the people that are going to rent, correct?
I think the intent of this request is to rent to people, locals who have boats, who can get to the Goat Island via a marina.
I understand. I was trying to figure out where they're going to park.
At his office.
Mr. Truslow, please make sure you're using the mic.
Well, he has 2 parking spaces where his office is. He's limited to 2 parking spaces there.
I'm not sure what the maximum number is there.
Doesn't matter.
2, you're
2 in total. And then if he's got boat slips, he's going to have a parking space. But the problem is, I think under the bylaws, you can't you can't use that for commercial purposes. So I'm trying to figure out how we can make this work.
He sent,
The applicant.
yeah, he sent an email and said that we do not anticipate our guests utilizing parking on IOP. In the case they need to, we have private parking at the Wild Dunes Yacht Harbor parking off 41st Avenue. We own an office at this location and several boat slips that allow us and our guests access to this private lot. So it doesn't specify a number.
Yeah,
That's why I asked the question.
yeah, doesn't matter.
I think it'd be better for the
No,
applicant.
I'm not trying to put you on the spot. I just,
No,
I
I
didn't know whether you knew.
understand.
Okay. Thank you. I appreciate it.
All right,
Any
any
other
other questions for staff? Is the applicant present? If you would state your name and address for the record and tell us why we should approve your request.
Okay, Benjamin Farmery, 2301 Waterway Boulevard, Isle of Palm, South Carolina, 29451. So like Mr. Ziegler said, we own this property on the southern point of Goat Island. We've owned it since 2020, and anyway, I think we think it's time to share with the general public and do some short-term rentals. It's been a second home for me and my family and my extended family that loves to come in, and if they boat, they want to stay out at our Goat Island property. So our intention is not to go through VRBO or Airbnb or use this property. One, I use it quite a bit. Dana Johnson, one of my property managers and colleagues in this business, she lives on Isle of Palms as well. So I think to just go straight to the parking question that you have, we really don't anticipate folks parking on Isle of Palms. If they do park on Isle of Palms, they probably are a resident of Isle of Palms. So they would drop their boat in, or their boat's already at Wild Dunes Yacht Harbor, all along Hamlin Creek. The interest that we're getting is through our local social networks. So I own 3 offices at the Carroll Building at Breach Inlet. If someone needed to, drop in near Breach Inlet, we have access there. I do own the office space in the Wild Dunes Yacht Harbor. I own 3 spaces and lease another in the Wild Dunes Yacht Harbor. So we have, if someone needed to park there, we would have access. And if someone was going to use one of those, we would probably escort them on one of our boats out to the property. That's not who we're anticipating, marketing to. Through Boat Life of Charleston and all these other popular social networks that are out here. There's ample marinas. We have friends in Daniel Island that want to launch in Daniel Island and come spend the weekend at our property and as a short little getaway. So, but beautiful property, in great shape. Like Mr. Ziegler said, we just built a 450-foot seawall to protect the property. We have ample docking space, so we have a great trash removal service plan. Dana and her husband, do a great job maintaining the property. I live at 2301 Waterway. This property is at 2301 Captain John Hutt Road. It's about as far from where I parked out in the parking lot, just across the intercoastal for me to access it. Dana lives in the 600 block of Isle of Palms. Her and her husband can access the property easily. So I own short-term rentals on Isle of Palms. I own a few restaurants on Isle of Palms. I mean, very active in the local community. So feel like we have a relatively large social network that we could tap into. And again, our goal isn't to just rent to anybody that we can't vet and know who's staying out there. So it's a little bit different than probably a lot of the short-term rental applications that you might see.
I want to remain focused for a moment on parking.
Okay.
And you're helping me. You say you've got boat slips or parking spaces at Breach Inlet?
So I have parking spaces at Breach Inlet. Yeah, the Carroll office building, and there's a little private where the boat. Are you familiar with the Boathouse restaurant? I take it, and there's that paved and graveled parking area. But again, we don't anticipate any of the friends that we have that own boats that are in those marinas. There's the 2 Island Marina behind the Boathouse. There's the marina that's behind the Carroll office building. Those are 2 privately owned. There is parking for those 2 marinas at the Carroll building. So they would be friends that own boats that are currently in a slip at those marinas. what I'm also saying is, the folks that have slips in Wild Dunes Yacht Harbor, if that's where they keep their boat, they obviously have parking in those parking lots.
Building, that's reserved for the tenants and people that are visiting them. Are you saying you've got, so those, got to exclude those. To the right of the Carroll Building, there's some
Gravel lot.
parking space. Are you saying you own space over there?
The Carroll office building does. The Carroll office building does.
But do
And
you-
I'm the
do you-
president of the condo association for the Carroll office building. So I also own a slip behind the boathouse. So up until 4 PM, you can park in the boathouse parking lot and access your boat in those slips. The Carroll office building, the 9 paved spaces that are in front, you're correct. They are for use, and then we do lease to the boathouse for after hours. The gravel parking lot to the right of the Carroll office building, that has access to that marina that is right behind the Carroll office building. So I believe there's 22 slips that
But
are.
do you have parking, do you own parking space there?
No one owns, the Carroll office building overall, the 14 offices that comprise the Carroll office building own those spaces.
Guests that go to Goat Island, can they keep their vehicle there overnight?
If they own a boat slip, if they own a boat that's in that slip, they can park there.
All right.
Mr.
I
Neal.
wasn't through, but you can go
No,
ahead.
no, I'm sorry. Well, wait. No, oh, wait. I thought you
All
were
right.
through. I'm sorry.
So I'm going back to the Wild Dunes Yacht Harbor. You've got a trailer there, correct?
Correct.
And you have 2 spaces, you have only 2 parking spaces there.
We have 2 reserved spaces there, correct. We have 2 reserved spaces there for the 3 slips that we own and the one that we rent for the boats that we have there. We have access to many more than that,
All right.
if necessary. But again, our goal isn't to have people drive to Isle of Palms and launch a boat and need a place to park. We're not trying to bring parking and more traffic into Isle of Palms.
I understand, but again, I've used this term before. In golf, you got to play them as they lie.
Sure.
We've got these. We've got to have something for parking. Now, continuing on the parking for boat slips, I'm sure you're aware, your bylaws don't allow you to engage in a commercial activity with those boat slips.
Sure.
So you've got 2 parking spaces. When we take the shell off the nut, you've got 2 parking spaces on the Isle of Palms that I'm not sure how they get in through the private gate. But you got 2 parking spaces and you've got a house with 4 bedrooms. And I'm trying to help me understand how you're going to be able to comply with the law.
Well, I was going to say, if and I don't know how many approved licenses are on GOAT now, but I can tell you no one has access to more parking than our property based on, property ownership and what's out there. So, but what I'm saying is, if someone owns a boat at Wild Dunes Yacht Harbor and they want to take their boat, they can park in their space. They don't have to use our space, I guess is my point. And if they live in they don't need to come over from all the other marinas. They don't, so I guess, are you saying the requirement would be to have 8 reserved parking spaces somewhere throughout Isle of Palms?
It looks to me you've got 2 spaces behind a locked gate.
Okay.
And I'm
Guess my
trying to
question.
figure out how it's not going to be a burden on anyone else or how you comply with the law. But I'll go to something else and just ask 2 more questions.
Sure.
And then I'm going to defer to my colleague to my right. I recall a couple of years ago, there was a business that was at your location. Some people called it the fish camp, and it got shut down for not being in compliance with the law. What?
No. So our intention was to do a fishing camp. So a lot of the charter fishermen had expressed an interest in that property. It's a well-fished point. So
But it got shut down, didn't it?
It didn't get shut down. We applied for our short-term rental license, and there was an existing structure. There was an old boathouse. There was the old Wild Dunes Yacht Harbor sales office had been detached during Hugo, and the owner in 1992 had it lifted up onto the property. So it was an old vessel that they ripped the engine off and converted to a 2-bedroom. So during our application process, they said that we had an unpermitted structure. So that structure, we, and we had already renovated the house and renovated that structure, but that structure was removed. So that's what has allowed us to finally get back into this position where we can, because we're in full compliance now with the property.
Okay, one more question, and then I'm going to defer to my colleague, Mr. Neal.
Okay.
Since the fish camp got shut down, you leased that property to anyone?
Have I leased it to anyone?
Have you rented it out to anyone?
We haven't rented it. I've had family and friends stay out there, but we haven't rented it.
You haven't rented it to anybody?
So, no, we're not renting it. So we've had a lot of people stay out there, and we've held events out there for friends and family, but we have not been officially renting it.
Mr. Neal.
Questions I always focus on, I learned from my former colleague, Mr. Marchant, and if he was here tonight, he would ask about the impact to the community, and I would focus on those two things. And I think I heard you talk about, you either have a property manager or you have somebody that lives close that manages it. So it's kind of a two-folded question. One, because this is Goat Island, this is a little bit different animal. It's not just your rental, sign it up for VRBO, and hopefully it fills up. Goat Island is literally a different animal. They can't just walk there. So tell me a little about, are there any regulations on Goat Island for noise or anything like that to make sure that this short-term rental is not going to impact that community? Because that's one of our criteria that we use to grant this approval for. And two, tell us about your property manager. Are you going to live there? Or I don't know, the structure's a 4-bedroom, so I mean, you're not far away, but your property manager is close. Just allude to those two issues for me.
Sure. I'll expand on all those. So yes, I live close. Dana Johnson, our property manager, lives very close, out there all the time. It's a big property to maintain and take care of, so we're out there all the time. I would live there, truthfully, if my wife and family would allow me to. So it's a beautiful property, as you can see in the pictures. That being said, we are on the southern point. So from a noise standpoint, we only have one direct neighbor. With that neighbor, there's a great tree line. We've put up a 6-foot fence, and I think a lot of this is in the packet. But as you can see on this picture here, thank you. We have the one neighbor directly behind us, and they spend about a weekend a month out there. So we also intend on doing very limited. I know we can do up to 144 days. That's not our intention. This isn't to overly monetize this property because it gets so much use from myself and my friends.
Notified your neighbor, or will notify your neighbor?
We have. We've spoken to the houses on Captain John Hutt Road, Marion Stone, and Bill Oakley, and the 2 permanent residents.
Give them some type of contact information if there's issues and stuff like that.
We've posted notices. We've given them notices. They all have Dana's contact information. They have my contact information. And you can almost see. Well, that is my dock, I believe, that you can see off of Waterway Boulevard, right there. So we are in very close contact. Being in the short-term rental business on Isle of Palms, we're very familiar with noise ordinances and how they operate. So we have printed material we're ready to put up, which will be consistent with what we put in all of our other short-term rental homes that we own and manage as well.
Thank you, Mr. Chair.
All right, thank you. Are there any other, Mr. Truesdale, you have another question?
Follow up on one thing. Your trailer in Wild Dunes Yacht Harbor, do you have employees there?
I have 2 employees that rotate through. So my main company is up in the Washington, D.C. area. So I have them come when they rotate through. They'll come through, or I put them in my office at Breach Inlet.
Again, I'm very focused on the parking. You've got 2 employees on Isle of Palms. They've got 2 parking spaces. If your employees are working, where are the employees going to? If you have people in your short-term rental and they park in front of your trailer in the 2 spots that you're allocated, where are your employees going to park?
My one employee walks. They own a property. They own a property about a block away. So they typically walk or ride their bike. I don't know if you've been there. I mean, we occasionally have one truck there, and that's usually my truck. So, but we typically I don't necessarily worry about the parking at the wild, you know, at that structure. If we needed to make it available for a renter, but again, we do not anticipate having anybody driving onto Isle of Palms that doesn't live there or own a boat there that has access to these lots. So we're not marketing to outside folks that would ever if they have to launch a boat from Isle of Palms and find a place to park, then they're probably not a customer of ours. They're going to go to one of the other 7, you know, approved places on Goat Island. You know, so we're really not trying to that's not who we're looking to attract. So, I mean, we could go down Hamlin Creek and up and down the Intercoastal Waterway and talk to you about the folks that are eager to rent. And again, I think they're going to fill the dates that we're looking to fill.
Mr. Truesdale, or I'm sorry, Mr. Jordan, you had a question?
You might have already answered this, but you say you can park here this time, park this place other time. How does your customers know all that?
Well,
where to park, when,
again,
how?
The question was just about the different access points that I have, a property that I own, I think that where I might have people park. But again, it's not, people park in their homes. You know, the people that we're talking about.
People's coming in.
We're not marketing to the people that are coming in. I guess that's the point that I'm trying to make, is that
So
we're
going to leave
we're
their
gonna
car
we're gonna not
at
work
their house and walk to your house?
No.
The applicant has testified
No.
that he's not going to be advertising on Airbnb or VRBO, but it would be more of a word of mouth type.
So David Hartness is going to walk from his backyard out his dock, fire up his boat,
right.
and drive his boat to
Or
Goat Island.
anybody else though?
Sure. Yeah, 90% of our customers are
Are they
going
gonna walk
to
from
come
the
from
pier to your
Sullivan's or
house?
Tollers or one of the other marinas. So, I mean that's how limited we want to be with this property. That's how focused we are. That's why we're not listing on VRBO or Airbnb.
What I'm asking is, when they get off the boat, how are they going to get to your house?
They dock, they walk up the pier,
Okay.
you know, and then they're right on our property. The dock is, maybe we have a picture of, can you
Okay.
show a picture of just our dock?
Thank you.
So our dock, and we have, you know, I think a little over 100 total feet of docking space there, but they'll dock on either, and it's deep water on both sides, so they can go on the inside or outside, just walk up under the pier head, and then it's another 20 yards, you know, onto our property.
Look like a beautiful place.
Yeah. Come visit.
I wouldn't come during a hurricane.
Yeah, well, that's why the new seawall is hopefully going to give us a few more years.
Would you be willing to let your renters know that parking might be limited or
Of course.
very little options
Sure.
for parking?
Yeah, that's my point.
Of course, and that's why, you know, we don't want to use any of these other platforms, you know, and we, you know, the other goat neighbors that we know that do short-term rentals, it's a constant challenge, because people go online, they think they're booking in Isle of Palms. It's just not something that, you know, it's not the direction we're going to go at all.
Just out of curiosity, did that home go through Hugo?
That home, well, I was going to say it went through, that house did not go through Hugo. That house, I believe.
Whatever there was before, was it tore down by Hugo? I'm just curious.
I'm not sure what was there before 1992, truthfully.
All right. Do we have any other questions for the applicant? All right. Thank you very much for your testimony.
Yeah, sure.
Yep. Is there anyone else here to speak in favor of this application? No. You don't have to. This is totally your discretion right now. I have to ask the question, though. All right. Is there anyone else here to speak in opposition to this application? All right. We shall close this case to the public. Board members, do you have any other questions of staff?
No, I'm ready for a motion.
I would entertain a motion. Yep.
Mr. Chair, I'd like to make a motion for approval of case BZA 04-2500858 for the special exception request to establish a short-term rental property extended home rental. I believe that the applicant has testified and convinced us of all three of the approval criteria. First criteria is compatible with existing uses in the vicinity and will not adversely affect the general welfare or the immediate community. You can see by the testimony and by the submittal of the pictures, they are at the very far end of Goat Island, and they have made accommodations to make sure that they will not impact their neighbors. They have a property management group on site. They live within a very close proximity, so I don't think they'll have any issues with approval criteria number 1. Criteria number 2, adequate provision is made and exists for such items as setbacks, buffering, fences to protect adjacent properties. Again, they are on the far end of Goat Island. Absolutely a beautiful picture and rendering of their property. They just won't impact anything. I mean, there's only one neighbor there, and they have promised that they're going to notify them and give their contact information. So that criteria is easily approved and complied with. The last criteria is number 3, complies with all applicable rules, regulations, laws, and standards of this ordinance. They've submitted their site plan. The issues, they've even added the issue that they may have limited parking, but again, they are not advertising to the general public. This is something that's a very limited scale use, and if you haven't been out to Goat Island, you obviously can't get there but by water, by boat. So I think the parking issues and things like that, they're complied with, but they do have other free parking in the area. So I don't think there's any issues whatsoever. Were there staff comments with this?
There are 4 conditions recommended by staff.
Yeah, so I'd like to include the 4 recommendations, 4 conditions added by staff as part of my motion for approval.
I have a second. Mr. Seidel. All right. So we have a motion that's been made and properly seconded. Is there any discussion? Mr. Truslow?
All right, there's nothing personal, but I'm compelled to comply with to obey the law as it exists. I live on the Isle of Palms. I know, and anybody who ever reads newspaper knows what terrible problems we have with parking there. It's a constant problem. The place closest to Goat Island, where there's a parking area, it's owned by a restaurant, and it doesn't allow the people from Goat Island to park there. Next to it is the marina, same thing, so they can't park close to Goat Island, or the closest that would across the ICW. You've got Breach Inlet, but those are private parking spaces. Then you've got a city lot and a county lot, but they don't allow nighttime parking. So I don't know where these people are going to park. They've got 2 spaces, but he's got 2 spaces in Yacht Harbor, but I haven't been convinced today that the bylaws allow them to operate a commercial operation for short-term rentals from that location. They've got 2 spaces, 3 employees, maybe one walks, maybe 2 of them walk. There's having 2 parking spaces that are competing with people in his trailer is just not reasonable. They're left with basically no parking. And the law requires, as much as I'd like to help, the law requires you to have parking, and there's not parking. There is no parking.
The staff assessment has indicated they don't have to have parking at the property. I know that presents another issue. That's not what you're challenging. What I would say is I am a very active boater myself, and I have done staycations in this town where I have left my car at home and taken a boat to the location where I was staying and used my boat for the week or the weekend or whatever the case may be. And the applicant has testified that's what his intent is. Now, could he rent it to somebody that it might have a parking issue? Yes, and if he discloses that to them, that is and they choose to park somewhere where they get towed, I would believe that would be on the renter more so than anybody else. I think it's a concern for Goat Island. It's a little bit outside of the scope of actually renting on that island, and I would support the motion that's been made.
Well, tow trucks aren't going to come. It takes hours to get off the island, and during the summer, during the most popular times, tow trucks don't come. I mean, the public is seriously affected. Deweese,
If it
Deweese
becomes an
Island is-
issue,
If I can finish,
there-
please. if I
okay,
can finish.
sorry.
Deweese Island is a perfect example. Deweese Island is nearby. They have 5 acres of parking for all the people that'll come, short-term rentals, residents, they've got parking. In this case, Goat Island has no parking unless somebody has already purchased a marina slip. There is no parking. So what we're doing is, we're in effect just ignoring the law.
I would,
There's no
I would
parking.
disagree with the
There's no
statement
there's no
that we're
parking.
ignoring the law. What we're having right now is an issue that's very similar to when applicants come here, or when neighbors come here for a extended home rental, and they just don't want an extended home rental in their neighborhood. And there's no basis to the fears that they might actually have that could occur, that there could be some type of random child molester that rents the place and is endangering their children. It's speculative to say that the renting that's going to be done here is going to cause additional parking issues on the Isle of Palms if the desired target client is not trying to park a car there anyway. That's all I'm trying to say.
Well, if we're going to dispense, if we're going to say there's no need to even address parking, then,
All right.
then we've opened up Pandora's box to a bigger problem than you might imagine. There's no
The
parking.
point is well made and it's taken. I appreciate the discussion and the back and forth. Is there any other discussion? All right, let's bring this to a vote. All those in favor, please raise your right hand and say aye.
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 All those opposed?
No.
All right, we have 2 opposed. Did you get both of those? Mrs.
3.
Smith? Mrs. 3?
Okay, Mr. Jordan.
Mr. Jordan, you were opposed?
Oh, okay.
That's right. Whip.
All right, the motion carries. Your application has been granted. You will hear from staff within 10 days about the final decision and the next steps in the process. Thank you.
How many more we got?
Oh, God, too
I
many.
appreciate that.
1, 2,
I appreciate
3.
that.
3, okay, we'll be here.
10 o'clock.
All right,
I'm putting my money on 10 o'clock.
our next case is BZA 0425000859. I believe it's going to be Mr. Ziegler
You
again.
use mine. Use mine. What do you want?
Their signs up, they're not allowed. They're not allowed. The ordinance doesn't allow overnight parking.
The next case is case number BZA-04-25-00859. The applicant and property owner, Dr. Stuart Middleton, trustee for the Daniel Middleton Senior Trust, is requesting a special exception to establish a short-term rental property, extended home rental in the special management S3 zoning district at 1843 South Grimble Road, TMS number 334-0000170 on James Island in Charleston County. The subject property and surrounding properties are located in the special management S3 zoning district. The property is 0.49 acres and contains a single-family residence with 3 bedrooms that was constructed in 1970 per Charleston County records. The applicant would like to rent 3 bedrooms and will provide 5 parking spaces. The maximum number of guests allowed will be 10. The property is not owner occupied, therefore the property is not eligible for a limited home rental. This is the zoning map showing the subject property outlined in blue. Here are the applicable zoning ordinance requirements, the 300-foot radius map, and a couple aerial photos. We posted the property on May 15th, 2025. And here's the subject property with proposed parking. 2 spaces will be in the driveway and the other 3 spaces will be in the front yard, parallel to the walkway. And here are some of the surrounding properties. And this is Grimble Road in both directions. And next we have some pictures provided by the applicant. The site plan, tenant notice, and plat. Regarding the approval criteria, we stated that it may meet 1, 2, and 3. The Board of Zoning Appeals may approve with conditions, or deny the request based on the BZA's findings of fact, unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the application, the board should consider the following conditions recommended by staff. 1, prior to zoning permit approval, the applicant shall complete the short-term rental property limited site plan review process. 2, the use shall comply with all requirements of Article 6.8. 3, this property shall not be used as a short-term rental for more than 144 days in aggregate during any calendar year. 4, the property owner shall be responsible for ensuring that tenants comply with the Charleston County Noise Ordinance. And we did not receive any public comments for this application.
Thank you for that presentation. Do we have any questions for Mr. Ziegler? We're good? All right, thank you very much. Is the applicant present? If you would come forward, state your name and address for the record, and tell us why we should approve your application, and we appreciate you waiting through these long hours to get to this point tonight for your project.
Yes, my name is Dr. Stuart Middleton, and I live at 3077 Winters Circle, Charleston, zip code 29417. First, I want to thank you for allowing me to present my application on behalf of my family. Secondly, I'd like to thank the BZA committee for working with me on this project. I made a couple of notes that's concerning this particular house. This house has been in my family for over 50 years. The house was the house for my grandparents for many years. They were known as hardworking, religious people and just good neighbors. My grandmother was a church leader and a spiritual leader for many people in the community. I spent many years in this house. I grew up next door. I go to the neighborhood twice every week because my brother still lives next door. As the years passed, my grandparents and parents, they passed away. The grandchildren grew up and they moved away to different areas. The home aged and no one lived in the house. My family and I pooled our resources together to renovate the house. I contacted several rental companies to help us manage the property. As for short-term renting the house, we have tried to comply with the requirements. We plan to maintain the character of the community. We restored the house so that it offers tourists visiting Charleston and other travelers a place to stay that feels like a home away from home. There are sidewalks for walking, biking, and jogging. There's access to the new James Allen Library located across the road. In fact, I can stand on the front porch and see individuals going in and out. There's easy access to Folly Beach. We have access to grocery stores, entertainment sites, so it makes a good location for individuals, tourists of all natures coming to the Charleston area. We plan to use the income for renting to maintain the house. We plan to use the property in a manner that does not adversely affect our neighbors. In fact, I submitted letters of support with my application from various neighbors. I spoke to neighbors in the community and no one had any adverse reaction to short-term rental. We plan to continue to keep the neighborhood quiet and safe. This is a neighborhood that I grew up in that I cherish quite a bit. I grew up in a neighborhood and did a whole lot, rode bike, played marbles and everything else, right there. Our plan for the setback, the buffering and parking for the house is to be adequate so that the occupants do not adversely affect the neighbors. With about a half an acre, we have a lot of area for greater than 10 parking. We made the following renovations to the house to make it feel like a home away from home. These renovations included the following: an upscale open floor plan, a master bedroom suite with 2 additional bedrooms, hardwood floor and tile floors throughout the house, new stainless steel kitchen appliances, new washer and dryer, new custom design cabinets, cable ready and Wi-Fi ready. The security system has multiple exterior cameras and floodlights on all corners of the house. The size and color of the house is similar to existing homes in the community. We plan to make the house that setting that tourists would be proud to come and feel as if they're in a home away from home. Thank you for your time.
Thank you, Mr. Middleton, for your presentation. Let's see if any of my board members have questions for you. Start with Mr. Seidel.
Dr. Middleton, thank you for your presentation. You mentioned that you had spoken to your neighbors. I think you also mentioned that your brother lives next door.
That's correct.
To this house. Who will be the person that you want the neighbor to call if there's some issue or some complaint about someone who's staying there? Would it be your brother, or they would call you? And how long would it take? I guess if it's your brother, he's walking across the yard. But
Yeah.
who is going to be the person
Well,
you're going to tell them
we
to call?
plan to, I've spoken to several management firms, and I haven't made a specific decision on which one, but we plan to have someone to manage the property.
And they would be available 24/7?
And they
during
would
the
be
time?
available 24/7.
Okay, thank you.
Mr. Neal?
Yeah, it's really just a comment about the party. It looked like half acre is what you said. I mean, it looks like a very large property, and you can accommodate a lot of parking, which I look at it at the flip side. You might want to designate an area, or they're going to, down the road, going to ruin some of your good, nice backyard and front yard and stuff. So I would designate a long aisle to be able to queue or stack some cars in there, because I think you mentioned they were going to park, or staff presentation said they were going to park in the front yard and stuff like that. But you've got ample parking. That might be something to think about down the road, 'cause if you let people park anywhere on that half-acre lot, they're going to ruin the rest of your grass and all that type of stuff. But sounds like, I love the letters of support being included as part of the application. That makes it very easy for us to see that we're not interfering with the community. So I applaud you for your application.
Okay, thank you.
Any other questions? All right, well, thank you for your time this evening. Is there anyone else here to speak in favor of this application? Is there anyone to speak in opposition? We do have one more to speak in favor. All right.
So quit selling.
Bill Goodwin, I'm with the Goodwin Group, local real estate firm. 78 Ashley Point Drive in Charleston is our address. Known Dr. Middleton for a long time. He's being real modest. He's a pillar in the community, and owning a property for that long. In my business, I just see a lot of people leaving town. So it's great that they renovated the house. Great that they got pride in where they're coming from. Great that the brother lives right next door. They also own property in the back of the property. 2 sides of the property they own, commercial property across the street. So this is a prime example. Sometimes people don't like these kind of uses, but this is a prime example of a use that keeps a family intact, keep the community intact, and keep some of the indigenous people that grew up in the area for decades to be able to stay and maintain the property.
Good deal. Any questions? All right, thank you very much. Anyone else to speak in favor of this application? Is there anyone to speak in opposition to this application? All right, we'll close this case to the public, and I'll entertain a motion from Mr. Truslow. He's already volunteered to make this.
Thank you, Mr. Chairman. It would please me to make a motion to approve this special request for a special exception to provide for a short-term rental. I want to start off by saying thank you, Mr. Middleton. That was one of the best presentations and submissions that we've had before us, and did an excellent job. That said, the in this case, 04, 25, and ending with 00859, the criteria set forth in 6.8, the three criteria have all been met. This use is compatible with existing uses in the community. I would incorporate by reference as findings the responses that have been given. They've lived in the neighborhood for over 50 years. They're familiar with all their neighbors. They've rehabbed the property. They're committed. They're community oriented. Adequate provision is made for setbacks, buffering, landscaping. They've really done a good job. In this case, they've got adequate parking has been provided. Number 3, that this complies with all applicable rules, regulations, and laws and standards of the ordinance, and is consistent with zoning. I would make this motion contingent upon the compliance with the staff recommendations 1 through 4. So that is my motion.
Got a motion? Where was the second? Is that Mr. Jordan? All right, thank you. All right, we have a motion that's been made by Mr. Truslow, seconded by Mr. Jordan. Is there any discussion? All in favor, please raise your right hand and say aye.
Aye.
Aye. That motion carries unanimously. Congratulations, your application has been granted. You'll hear from staff within the next 10 business days regarding the final decision and next steps in the process. Thank you very much for your time this evening.
Sorry I had to wait.
All right, our next case involves another short-term rental. It is BZA 0425008660. Mr. Ziegler, take it away.
The applicant and property owner, Art Wilder, trustee of the Arthur and Marlene Wilder Trust, is requesting a special exception to establish a short-term rental, extended home rental in the Soul Degree Community Overlay Zoning District at 2046 Soul Degree Road, TMS number 330-1100015 on James Island in Charleston County. The subject property and surrounding properties are in the Soul Degree Community Overlay Zoning District. The property is 0.61 acres and contains a single-family residence with 5 bedrooms that was constructed in 1959 per Charleston County records. The applicant would like to rent 3 bedrooms and will provide 5 parking spaces. The maximum number of guests allowed will be 10. The property is owner-occupied, and the owner obtained a limited home rental permit in 2024 that has since expired. Here's the zoning map, the zoning ordinance requirements, the 300-foot radius map, and a couple aerial photos. We posted this property on May 15th, 2025. And here is the subject property with proposed parking. There will be, 1 space will be in the garage, and the other 4 will be in the front yard. And this is some neighboring properties. And Soul Degree Road in both directions. This is the site plan, tenant notice, and plat. Regarding the approval criteria, we stated that it may meet 1, 2, and 3. The Board of Zoning Appeals may approve with conditions, or deny the request based on the BZA's findings of fact, unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the application, the board should consider the following conditions recommended by staff. 1, prior to zoning permit approval, the applicant shall complete the short-term rental property limited site plan review process. 2, the use shall comply with all requirements of Article 6.8. 3, this property shall not be used as a short-term rental for more than 144 days in aggregate during any calendar year. 4, the property owner shall be responsible for ensuring that tenants comply with the Charleston County Noise Ordinance. And we did not receive any public comments regarding this application.
All right, do we have any questions for staff? Thank you very much. Is the applicant present? If you would come forward, state your name and address, and tell us why we should approve this request.
My name is Art Wilder. My address is 8560 Crystal View Lane in Flagstaff, Arizona. And I'm here on behalf of my parents who, my dad was born and raised basically on Soligree. And once he raised us all in LA, they retired and they've lived on Soligree for the last 20 years. Our family owns land on Soligree since, just after the Civil War. So lots of relatives. So recently they've had to move in with my sister in Atlanta for health and memory care reasons. And so we wanted to turn their home into a short-term rental so they can come back whenever they choose for family functions, reunions, finish documentaries and recording life on the island and Gullah Geechee culture, and to help bring in income that would help care for the home and pay my sister for caring for my parents. So we have we've done a lot of renovations to the home since we started, new roof, some new electrical work, new air conditioners, and some of the work we've noticed while the house was unoccupied. And so it's nice to have someone in there, property managers checking on the place, to keep it up to date, and then to have income to do that as well. We have a property manager already lined up, so if we do need to call someone at 3 in the morning, I asked him that specifically. He said, yeah, we have someone to take care of you. So that's it.
Well, thank you, Mr. Wilder. I will say that your application for an STR is probably one of the most thorough that I've reviewed in my time as board. I don't know if my fellow board members have had a chance to peruse the attachments, but thank you for the thorough application.
I appreciate that.
And the architect in the bunch is impressed with the floor plan, so.
Oh, sure.
All right. Are there any questions for this gentleman?
You're not going to drive out to Flagstaff now, are you?
Fly it out tomorrow morning, 7 a.m.
Well, thank you for enduring this long evening here.
Oh, sure.
All right. If there are no questions, we thank you for your time, and you can be seated. Thank you.
Appreciate it.
Is there anyone else here to speak in favor of this application?
Nobody else left.
Is there anyone here to speak in opposition to this application? Okay.
Thank you, Mr. Sardell.
Good evening. Ross Settle, 2170 McNeil Washington Road, Charleston. I have not had the pleasure of meeting the Wilder family. I have neighbors that know them, and I understand it's a very fine family. I hope to get to meet the family at some point. And I'm not opposed to a long-term rental, but I've heard horror stories about short-term rentals. In fact, I had one recently in Florida where my family was there, and it was a gated community, in fact. And it was very nice for every night we were there until the night before we were leaving. And a neighbor 2 doors down had about 30 people over. It went on until about 2 o'clock in the morning. And I'm sure that the intent of the Wilder family is not to have situations like that occur, but they wouldn't necessarily have to be here to endure those type of sleepless nights. So again, I'm not oppositional to something like a long-term rental, but with the short-term rentals, such as what has gone on at Folly Beach over the last few years, you have a lot less control over who's coming, who's going. Many of you may know that this property is very near Folly Beach and also very near the Soligree boat landing. And in some of the literature that I noticed that was presented, both Folly Beach and the boat landing were mentioned. So my guess is that they would be marketed to boaters and to people that are going to be going to Folly Beach. In particular, the parking, while there's space for it, there's no defined driveway, there's no defined parking, and I wonder where the boats and the boaters and the trailers that go along with that, where that would be. I'm assuming all in the front yard. So my other concern is that there's nothing in place by the homeowner to help prevent noise, especially from leaving the property. Yes, there's a fence on one side that was installed by a neighbor, and there's a road between that and the neighbor. There's also a fence behind the home, but it's a split rail fence. And noise will travel readily through that. There is some vegetation and things of that nature to help filter some of that, but my opinion is it's inadequate. And so I just respectfully like you to consider to deny this request. And thank you for your time and for your service.
Thank you for being here tonight. Can you show us where your property is in relation to the?
Exactly what I was asking.
Okay, so
Come to learn what people might ask.
one of the homes that is on McNeil, Washington, actually has an address on Soligree Road, but it would be the Wilder's neighbor to the left if you're facing the house from Soligree.
Can you tell us a number from up here? Walk up here if you have to. I can't see it either.
2046 is Mr. Wilder's property. I think it's 2040.
Will it be a different number here, though? What?
These are TMS numbers.
2040 Soligree Road. Soligree Road.
I got
It is Shane Estes' house, the new house.
On the other side with the fence?
Correct.
Okay.
027.
Yeah.
So he's directly behind them.
I'm not directly behind him. I'm Ross Settle. Can't believe first time I've been in a room with 3 Rosses.
It's a very infrequent occurrence, so something bad is going to happen on the way home tonight.
Don't say that.
Let's hope not.
027, Ms. Working?
Well, that's owned by Libby Richardson, so I don't know. That's what's showing up as 20.
2170 McNeil, Washington is my address. My neighbor, I think you were asking who was next door.
No. We were trying to figure out where you live.
I'm sorry. So I live one street over and 2 lots behind. So there's a house next door to the Wilders that's a newer home that's pictured in one of the. And then there's a vacant.
We'll give you a chance to come back up in a second, Mr. Wilder.
096 on this map?
Okay.
So I live one street over. There's a home next door to the Wilders. Then there's a lot that's partially cleared, and then my house.
Okay. We have other questions for Mr. Settle?
You made a comment about the boat trailers and stuff like that, and you made a comment about noise. I mean, there's going to be noise ordinances that they have to follow. So we always comment to applicants to make sure that they give out information on how to be the property management groups and stuff like that. But the question you're bringing up about parking and stuff, I don't understand how boat trailers and things like that come into play here. I mean, I would imagine if a guest is coming and bringing their own boat to use down there, that's an accommodation. But are you worried about parking? Because I believe he submitted a plan that shows all of the parking. Can you pull that up? And
Right.
see?
I saw that, and
I mean, is that
I agree
something
that
you're
there's-
worried about?
I agree there's ample parking, but I'm also concerned about the value of my property if there are cars parked in the front yard of a neighboring property.
That's
I
why I was
didn't
asking
mention
you.
that. I didn't
I was
mention
trying
that.
to understand what your concern is, and that's a very valid one. I was just making sure that this site plan shows where they would put cars and a boat or something like that. I'm sure.
I don't know how they would turn around, to be honest with you, because you can't, it'd be very difficult to back in off Saul Agree Road. A lot of trees, a lot of, there's no sidewalks. They've been approved for sidewalks, but they're not built. That made the news recently, but, you know, my concern, a selfish concern would be, you know, just cars parked in the yard.
Sure,
and,
that's fair.
And the effect that it may have on my value if I go to sell my home down the road.
Right. Right, thank you for that.
I have other questions for Mr. Settle. One thing we will point out, if this is granted tonight, the permit is valid for a year, and then the applicant has to come in for renewal. So if there are substantial issues that you face as a neighbor to a property like this, and you bring it to the county's attention, there's always remedy later on for actual issues that you may experience once it becomes a rental property. You might find that there are no issues, and it may not, you know, your one-off experience in Florida hopefully will be different if this is passed tonight.
Thank you.
All right, thank you for your time.
Great comment.
Is there anyone else here to speak in opposition to this request? I'm thinking not. I think the last two gentlemen are for the last case of the evening. So, Mr. Wilder, you have a couple of minutes to rebut if you so choose to do.
So when my parents moved to Charleston, their house became sort of a hub for family events and class reunions. So I think having many cars in the front yard has been a thing for the couple of hours that you would have a party and then they would all leave. And there is plenty of room in the backyard if we wanted someone to park a larger vehicle off, so you can't see it from the road. We just didn't like the idea of driving. There's a prescriptive easement between my parents' house and the neighbor's house. We still didn't like the idea of having people start to park in the backyard, even though that's been our family. When I say our family, uncles, aunts, cousins, that's been the custom. Everybody parks in the backyard. There is room. We'd rather people park in the front yard. And there has been room to turn boats around and park boats in the yard. So there's been, and there will be a property manager. You can definitely have his contact info if you want. If there is any issue, we would definitely not want to affect the neighborhood in a negative way. We hope that this is an example for people in the neighborhood who are aging out to sort of preserve their homes, because we've seen too many homes sort of just rot because family can't solve it, or they don't solve, they can't solve issues, or they don't have the money to have an upkeep. So we want this to be an example. So we definitely want to do things that would have our neighbors be happy with what we're doing.
Any questions for Mr. Wilder? Mr. Jordan?
I'd just like to say, please keep this in mind, that a big issue with this board has been make sure your property manager will answer their phone late at night, and if they have somebody available to come out there if there's a problem. Please keep that in mind.
Yeah, definitely. I asked him, his name is Alex Gregory with the Boroughs. I said, will you answer the phone at 3 a.m. because I watched a previous board meeting when one of the board members asked a prospective short-term rental applicant that. He said yes, he may not, but he has 2 other people who answer. So I haven't tested him on that, but I've had some leaks and things that he's taken care of promptly. So so far he's proven to be on his P's and Q's.
Hopefully he didn't fix that leak at 3 a.m. in the morning.
No. Thank you.
All right. Well, thank you, Mr. Wilder. We appreciate your testimony. All right, this case is now closed to the public. Was there any questions for staff? We have a motion.
Sure, I'll make a motion.
Oh, I'm going Mr. Brown. He's been.
I'll jump in here.
I make a motion to approve the short-term rental for BZA Project 0425000860. It appears Mr. Wilder has met all the requirements of the short-term rental approval criteria for Article 6.8, short-term rentals. Number one, it's compatible with existing uses in the vicinity. Obviously, these are all homes and, excuse me, it will not adversely affect the general welfare of or character of the immediate community. It's going to stay a single-family appearing home and work within the community that way. There's adequate provisions have been made for such items as setbacks, buffering, fencing, and protecting adjacent properties from potential adverse influence of noise and traffic and parking. There are fences and parking taken care of there. Complies with all applicable rules, regulations, laws, and standards of the ordinance, and site view, and they're following the site plan review requirements of the ordinance. So I'd say that plus what are the four requirements stated by staff?
All right, that's your motion?
That's my motion.
Have a second?
I second. I'd like to make a comment, though. I appreciate the residents' concern and appreciate his input, but often you make an observation, often you're better off with an occasional issue with short-term rentals than you are if you had a bad long-term tenant. Much better off. Occasionally you get a bad one. You may be better off. Second thing is my experience. I live on Isle of Palms. We're getting lots of short-term rentals, and we find out that it raises the prices of property nearby. It doesn't cause them to decrease in value.
All right.
Thank you.
Thank you, Mr. Truslow. So we have a motion that's been made by Mr. Brown and seconded by Mr. Truslow. Is there any discussion? There being no discussion, all those in favor of the motion, please raise your right hand and say aye. Aye. The motion carries unanimously. Your application has been granted. You'll hear from staff with the final decision within 10 business days. Please contact them for the next steps in the process. Thank you, Mr. Wilder. All right, our final case this evening, I don't think includes any letters of opposition, and there's nobody else in the room except what I'm guessing is the applicant and his agent. And it is BZA 0425000861. Ms. Working.
The applicant and property owner, James Dugan of AMDG 17 North LP, represented by Kyle A. Taylor, PE of Taylor Consulting Group LLC, are requesting a variance to reduce and eliminate the 8-foot perimeter landscape area required along the property adjacent to TMS number 578000028 and to eliminate the 15-foot landscape right-of-way buffer required along the ingress-egress easement for existing and proposed parking at 2521 Highway 17 North, TMS number 58014000031 in the east area of Charleston County. The 1.98-acre subject property and adjacent property to the north is located in the Mount Pleasant Overlay Village Commercial Area from Isle of Palms Connector to Hamlin Road zoning district in the Sweet Grass Basket Stand Special Consideration Area. Surrounding properties to the south and east are located in the Mount Pleasant Overlay Residential Area zoning district. The project is currently in the site plan review process. The applicant is proposing to construct two 4,060 square foot office buildings. And the board heard this variance request. It was BZA 0424000772 on June 3rd, 2024, and voted to deny the request because they found by a vote of 4-3, the request did not meet criteria 6. The BZA's order stated the BZA finds that the need for the variance is the result of the applicant's own actions. Specifically, the applicant is redeveloping the site and can design a plan that meets the required buffers. Then at the July 1st, 2024 BZA meeting, the applicant requested a reconsideration. However, no motion was made by members of the prevailing side. The applicant filed an appeal with a request for pre-litigation mediation to Charleston County Circuit Court, and that appeal is still pending in Circuit Court. This is the zoning ordinance requirements, the overlay maps, the radius map, aerial. We posted the property on May 15th, 2025. And this pictures of the current parking and current building, existing building. And Highway 17 North, again, the site plan. This is one of their exhibits, the access easement. And this is the vehicular area perimeter buffer exhibit, landscape buffer plan, and the elevation, and the plat. So regarding the approval criteria, we stated that it may meet 1 through 4, and 6 and 7, and that it meets 5. The board may approve the conditions, or deny the request based on the board's findings of fact, unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the application, we have 2 recommended conditions. 1, prior to zoning permit approval, the applicant shall complete the site plan review process. And 2, prior to zoning permit approval, the applicant shall obtain a certificate of historic appropriateness from the Charleston County Historic Preservation Commission.
We have questions for staff. Mr. Neal?
Yeah, I'm trying to understand what is different from this application that got denied and then appealed than what's in front of us today. And it still resembles, they got a problem because of the tower, right?
Yeah, they can point that out more specifically, but the buildings are slightly smaller, and so there's less parking, and they added a little bit more landscaping and tree islands. So it is it is slightly different than the previous application, although they're not required to change the application because it has been 1 year waiting period.
So I guess I'll save my question for the applicant to show me the difference in the original application.
Yeah.
And what's going on here then. Thank you.
That
Thank
was
you,
just
Ms.
a brief
Barking.
summary, yeah.
Yep, thank you.
Mr. Brown?
Did you say that it's currently still in litigation?
Correct, it's just, right now, it's just been continued until this hearing.
So does this decision have any bearing on what's in litigation, or are they 2 separate things?
They're 2 separate things.
It still runs.
I think if they get approval tonight, that they'll probably drop the appeal, but right now, it's just been continued in court. No, they haven't heard the case.
Any other questions for staff?
And that was for that
Nope.
previous case. So this is a brand-new case,
Yeah,
different
it's a new
different
plan.
application.
Which is not being considered in comparison to that previous one? This is
I wouldn't,
like, I'm
I
curious
mean-
too what the difference is,
Yeah.
but I
Yeah.
didn't
Let
see.
the applicant say, just
Okay.
Yeah.
hold off from
Yeah.
staff and let's let the applicant go.
Any other questions for staff? All right, thank you, Mrs. Working. Is the applicant present?
I hope so.
Please state your name and address for the record and tell us why we should approve this application.
Yes, sir. And I've got some handouts as well that I can pass out to everybody. We can hand all this out. Yeah. So there's 11 copies of the 2 primary exhibits that we can go through. And
We'll see.
And my name is Kyle Taylor, Taylor Consulting Group. The office address is 22 West Edge Street, Charleston, South Carolina. And we are here closing out the evening. So thank you for your patience here. We are happy to close it out. Also here with a company representative for the property owner, Mr. James Duggan. For the property owner applicant, AMDG 17 NLP. And this is, and those are all for everybody. Yeah. There's 2 separate exhibits, so 11 copies of the 2 separate exhibits. Yeah, there's 2 separate exhibits in there for the two buffer requests. I'll try to be thorough and hopefully concise as well. to respect our time here, but we are requesting approval for these two buffer requests for this subject property. The property is abutting Highway 17. It is situated with the former Boone Hall Farmers Market building, which is now being used as a furniture store, and I think is doing well. The proposed improvements are for the two office use buildings at the rear of the property. One of the exhibits from GIS that staff presented, I think, shows some old property lines, so it is currently one property. It's not two properties. And it's one property, 1.98 acres in size. As a bit of a preamble introduction before getting into the buffer request, this is somewhat of a reapplication. There are some material differences. We've reduced the building size and the parking and added landscaping. There's no use buffer reductions requested. All the use buffers are provided. So there's residential use to the south and some residential use to the east. Those use buffers are provided in this plan. There's no use buffer reductions. So the buffer reductions for this request are sort of an internal reduction for the access easement that runs through the property, and for the 8-foot vehicular perimeter buffer to the north, and that property is also zoned the same as this property, which is village commercial. So this is all commercial zone property, and those are some material changes. This is somewhat of a reapplication. There was a thin margin to reject this request, and as staff noted, it's currently under litigation as the request is needed, or else the property would have to remove all existing parking, and hopefully we can help explain that maybe better so that we can help demonstrate that this request merits and would warrant approval. And respectfully, I think last meeting, which was about a year ago, there was a bit miscommunication in I don't want to speculate exactly what happened, but there were a few opponents that I think we've helped cross some boundaries and barriers, and the owner has met with the adjoining community, and there's no opposition here tonight, no comments in opposition. The owner met with 30-plus individuals of the adjoining community, and I think they had a good meeting. And so, but I think there was some miscommunication on some opponents' parts that were at the last meeting a year ago, and it resulted, unfortunately, in a slim margin in rejection. But we believe this request warrants, and hopefully warrants approval, and we request your consideration. To briefly go through the two main exhibits, if we can maybe pull up, staff, could we pull up the access? Oh, am I able to, okay. Oh, I thought it was just a laser pointer. I got you. And I'm happy to go through any of these exhibits, but I think the two pertinent exhibits, the first one would be the access easement buffer exhibit. What's shown in green shows what the zoning ordinance would require to be provided on the subject property to meet the 15-foot access easement buffer requirement. And so in Charleston County, essentially every road right-of-way has a buffer requirement, which is provided at generally the front of every property, and that can range anywhere from maybe 15 feet up to maybe 75 feet. It depends on the road that your property is abutting. In this case, the property has an access easement which serves some current vacant undeveloped lots to the east, which this property owner did the subdivision, and so they're currently vacant. There's no neighbors there currently to the east. But every road right-of-way has a buffer. Usually that's at the front, but in this case, the access easement runs through an existing drive aisle, and the drive aisle is proposed to be extended with pavement. And so that runs through the property, and there's parking existing along that access easement, and there's parking that's going to be provided, and that's essentially where the parking has to be provided for the layout. And the layout for the front 1 acre that's currently situated on the property, the front 1 acre that's developed. That's been there for decades. I don't know exactly how many decades, but I believe it's been 50-plus years that front acre's been developed. And so that parking's been there along that access easement since that time. And so the owner's proposing to do 2 small office buildings. The owner's reduced the office buildings pretty significantly over the course of this project. The owner's been working on this project for a number of years now. It's gone through some pretty tough hardship to get to this stage. And so that is the request for the access easement buffer, that buffer would be waived, and the remaining buffers along the residential sides and such are fully provided, and there's some pretty tremendous landscaping that's being provided. And I'll flip then to the second main exhibit for us. The vehicular area perimeter buffer. So that's a requirement for 8 feet for landscaping around perimeter buffer, perimeter parking areas. And so the parking area for the front, again, which is existing and already developed, that parking goes up to essentially right up to the property line. And that was done, of course, before these buffer requirements were made into the zoning code. So that parking is existing up to the property line at the front of the property. And that frames the site, and it frames the layout, and it frames the drive aisle, which goes through the property as well. And so in the same manner, the new parking is situated along the northern property line as well. We can provide a little bit of landscaping for the new parking because we can situate that a little bit. We have a little bit more control over that than the existing. So there's about 2.5 feet of landscape buffer area there between the edge of the parking and the property line that we're able to provide some vegetation. But we're requesting a reduction for that 8-foot buffer for the new parking. And it would seem we would need the full waiver, though, for the existing parking area, or else we'd have to cut out 8 feet from the existing parking, and that's not feasible. We can't provide a full parking stall and the full drive aisle with that reduction. So those are the requests, and I'm happy to answer any questions about those requests. The 2 buffer requests, again, the use buffers are fully provided, and the 2 buildings, again, have actually been scaled down pretty significantly. It wasn't necessarily a variance requirement to reduce the buildings and provide more landscaping, but the owner has provided those changes to the plan that's in front of you, which are changes that were made since this plan was provided to this board last. I'm happy to answer any questions, and we humbly ask for your approval here tonight.
Sure. To get started, I want to. Can you pull up the aerial view of the existing aerial view that shows the building that's out there? It's probably pretty early in the presentation.
There it is.
All right. I'm just trying to make, so essentially what you're asking to do is carry that existing parking arrangement, entryway arrangement just further down the property line, correct?
That's correct.
Okay. All right. Mr. Neal?
Thank you, Mr. Chair. I remember this property very well from when it came a year ago. And I was one of your no votes, unfortunately for you, and I apologize, but sometimes I do vote no. The problem that I recognized with this property before is that the cell tower is right in the middle. If you'll go to, can you click to the one that shows the easement all the way through that's got the green on both sides? So the problem with this in your first rendering, in your first submittal, was that you've got the easement going through to the property. The chair just showed the aerial. There's 2 or 3 properties all the way back. And so they've got to have this easement through the property. So basically you have a road through your property that you want to use as a parking lot. Now the front part is fine because it is a parking lot and it is what it is. But there was also some agreements taking place in Mount Pleasant years ago with Mr. Freeman and his group. I'm sure you're aware of George Freeman. If not, that's fine. that they didn't want to turn roads any more out onto 17 Highway that accessed more of the historical communities back there. So they asked the town of Mount Pleasant or the county, somebody, to limit access all the way through. Well, these people still have to get back there. So if a car is going to be driving through what you're limited your area, because if you got 2 office buildings, you've basically got a street there, and I have problems with parking cars next to an easement. And the only reason you have to have those parking places is because you have 2 office buildings. So if you had 1 office building, and I can't design your property for you, but if you had 1 office building instead of 2, you wouldn't have to have all the parking requirements, and then you could configure the parking around the cell tower area and the lower area, and you wouldn't have to put all that parking up in front. So now your new application has brought you where you're trying to get rid of the variance to get rid of the buffers so you can still park. And the whole issue is you're putting 2 office buildings there when probably 1 fits if you didn't have to access it. So although I understand your submittal, I can't support it like this unless you can tell me why you have to have 2 office buildings, and that's why you failed the test last time on number 6, because it's of your own making. If you had 1 office building there, you could probably have enough parking to do what you needed. How do you convince me that you're not making this problem work yourself? Does that make sense?
Your comments are received. Yes, yes, sir.
Okay.
I don't know if this is my time to respond.
No,
or-
yeah. I'm asking you the question.
Okay.
It convinced me why this isn't your own making. Can you live with 1? Why does it have to be 2 office buildings that are generating all the parking problems, so you asking for a variance?
Yeah, well, there's a couple of things there. The first would be the front of the property is existing. So as I understand, no matter what happens to the rear of the property, whether it's 2 buildings or 3 buildings or 1 building, nothing can be proposed to the property unless the front parking is removed, because the access easement buffer is required along the entire access easement, which includes the existing portion of the property. And so, notwithstanding whether it's 1 building or 2 buildings or even more buildings, my understanding is
You would have less
parking.
parking requirements if you had less square footage. The parking is determined by the square footage of the building, right?
Parking requirements are determined by square footage of the building. The parking at the front of the property, I mean, frankly, from a site engineering perspective, I don't see removing the existing parking at the front of the property, at the very least, at all being feasible or functional. And so my understanding is the application of this landscape buffer requirement would mandate to remove all existing parking.
Okay, well, I'll frame my question if I can interrupt you then. Let's take the front section of the building, the existing section, out of it and say the variance would just be from the back half of the property where the new parking would be. If you had 1 building instead of 2, you wouldn't need as much parking back there, and you wouldn't need the variance to apply in that condition, in that area. Correct? I'm trying
Well,
to
I think
keep
that-
parking away from an access point where you're going to have to go through the other, all the way through the back end of your property. And that's where the problem I have is you're putting so much area, so much square footage back there that you have to have parking. And if we could eliminate the parking next to that access easement, I'd be fine. But I haven't seen a plan that allows me to do that. And that's why I voted in the first plan. I don't see how I can support it unless you can tell me how we can not have parking around your access easement. And the function of the parking is how big your square foot of your buildings are.
Well, I would also make the point too, the result of the last BZA meeting, I believe the rejection used some terminology that the owner was redeveloping the property, but I see it differently. I don't see this as a redevelopment. The front of the property has been looped into the scope, because generally when you go through site plan review, you have to bring somewhat of the whole property up to zoning code. And so that's actually resulted in some what would probably be considered to be improvements to the front of the property with cutting in landscape islands, which aren't there currently, which adds costs and adds some things, but adds some greenery to the scope. But cutting in landscape islands, adding landscape buffer plantings, especially along the south, that's not there currently. So the front of the property has gotten looped into the scope, and that's resulted in some improvements. But that's also resulted in that being viewed as part of the application. But the rejection used that terminology that the owner's redeveloping the property, but I would just have to press back a little bit on that that's not the intent, because the owner, as far as I know and believe, the owner has a great tenant in the front of the property and hopes that continues to thrive, and we don't want to mess that up. In the rear of the property, in the same manner, to continue any development to the back half acre, it's just situated with the constraints with the site dimensions and the cell tower, that any other program, meaning any other layout for any improvements, is essentially infeasible to extremely cumbersome to do any other layout other than extending what's essentially been there for the last 50 years.
Mr. Chair, can I just follow up to one? Well, the scenario I'm giving you to try to salvage it is, if you add one office building there, do you agree you would have less parking requirements, which would allow you to move the parking away from necessarily being in that easement, being next to that easement? Is that a reasonable assumption?
Well, as a general statement, reducing square footage reduces necessary parking.
So if you had one building instead of two, you'd have half the amount of parking needed because they look like they're symmetrical, and then you could at least maneuver some of the parking around where the other building would be. Is that reasonable? I'm good, Mr. Chair.
All right. Ms. Smith, you have a question?
I guess I can't rebut him.
No,
I don't
but
think you can have
you can ask the applicant.
I don't think, would you, if you had one building, if you only did one office building, would you be able to have disabled parking near it? If you decided to do the parking where the other building was, then you wouldn't have a place for disabled parking, right? I don't see how the lot is buildable.
The ADA route would be challenging.
Do you have any restrictions on building 2 stories? I was just curious.
That would be sort of a diving more into zoning restrictions in this area. I can say with quite a bit of certainty, though, that there are other uses that are allowed in this area, and we are quite well below the maximum square footage allowed for the buildings.
And this is all landscaping that you guys have added in the front? All these circles, y'all are adding additional trees and landscaping?
Are you looking at a certain exhibit or a different exhibit?
Let's see. It shows 2 buildings and then
Your actual
The
landscape
landscape
plan.
Yeah, so all of the circles there, all the blocks are new trees and new landscaping. There's quite a pretty tremendous amount of landscaping, primarily as a result of the landscaping requirements in the 25-foot land use buffers, which extends along the entire south and the east.
Okay, thank you.
Thank you.
So, Mr. Taylor, how long has that access easement been in place on this property?
So access to the rear, so that's the east. Access to the east, it's always been residential to the east, and this property's been commercial, so it's been separate properties. So that's been going on over 50 years. And there's always been access provided through this property to the residential in the rear.
And how many lots are on the backside of this property, on the east side?
To the east, there are 4.
So we have essentially an access easement that's been in place for some number of years that accesses 4 residential lots behind this facility. Okay.
Are the 4 lots developed?
So they're vacant. They're in the process of some development, but they're vacant. There's no structures.
Any other questions, Mr. Brown?
Yeah, I'd like to keep going.
Yeah.
So were you told in the site review process that you had to bring the easements and the buffers all the way out to 17?
Yes.
That was directed by the county or whatever to bring those out there, okay? And this existing cell tower, that, I'm assuming that's a leased property that's on this location?
There's a cell tower easement lease, yeah.
Okay. And my line of questioning would go back to what Mr. Neal was saying is, you know, one building, you replace one building with parking, and a lot of your issues could potentially be resolved. Have y'all looked at that? Has that been investigated as a solution?
Well, I would have to strongly disagree that removing one of the buildings and putting parking there removes the need for the access easement buffer requirement.
Well, that's
what I said, yeah.
Yeah,
that's not what I said. You could just I'm sorry, I'm not on the floor.
That's not what you were saying. is it?
No. I'm just saying he's got the number of parking spaces that are being required because of the square footage of the 2 buildings. I'm not saying he doesn't still need a variance, but he's got other parking. He's got parking on both sides of the access easement throughout the property. So he might only have to have it on one side of the access easement, but not both sides. So right now, you're going to park cars off of an access easement based on the square footage of 2 buildings.
I think our solution is getting towards the same thing of
Right.
not needing
If you didn't have
variance.
if you didn't have to have 100 spaces or whatever it is, he could reconfigure. I don't know how, but he could reconfigure around the cell tower, around the other stuff, and not have all the parking spots parallel both of the access easement all the way through the property.
We were saying the same thing. Wherever that other parking that's required goes.
But if you
is
needed
one
a
thing.
variance, it could be a smaller variance, probably.
It'd be a much less intrusive variance. Gotcha.
Are there any other questions for Mr. Taylor? All right, thank you, Mr. Taylor.
Thank you.
Is there anyone else here to speak in favor of this application?
My name is James Duggan. I'm at 1460 Patterson Avenue, Charleston, South Carolina, 29412. One of the owners of the property. We're here at hour 5. I apologize. I'm keeping you here 1 second later. I got here at 3:30. Y'all probably got here earlier than me. I have a 8 o'clock rule that everybody's got to get out of my house on a weekday. So I apologize.
okay.
I'm keeping you here later. But to piggyback on what Kyle said and to address these 2 gentlemen's comments and to look at the 7 criteria for a variance, do we have extraordinary, exceptional circumstances for this property? Very extraordinary. The private lane, this private lane isn't 50 years old, it's 100 years old. The back of this property, the east of this property, has always been residential. The front of this property has always been commercial. I'm very familiar with the property. Y'all may know the Hamlin name. The Hamlins own this property. The Hamlins' home was in the back, and they had a secondary structure back there. So basically, they had 2 residential units in the back, going back 100 years. And in the front, where Boone Hall Market Deli was their packing shed, tomato packing shed, the farmers. So there was always residential in the back, always commercial in the front. This private lane, this access easement, as we call it, for application purposes, is 100 years old. You can go there and see the ruts in the road today that look 100 years old. So it's very unique. The property's long and narrow, very unique. It's an extraordinary situation. The cell tower's been there about 40 years. The packing shed goes back about 60 years. It was converted into this market deli about 25 years ago. But before that was on the exact foundation was the tomato packing shed. All of those conditions, all these weird, unusual conditions existed long prior to these buffer requirements. So this is very unique property. So those are the first two criteria under the variance request. If we applied if we fully comply, if we didn't ask for a variance, we'd have to eliminate about 50 parking spaces in the front of the property, up there where the commercial building is. So that's why we're asking for the variance, so we don't have to remove those about 40 spaces. And I hear these two gentlemen's comments, well, maybe if you only had one building, we'd just let you keep those there, that we'd give you the variance. It would be because we'd see a less intrusive use. And I think if you eliminated one of the two buildings, yeah, you could park cars where the second building would have been. Sure, you could do that. But you also would still have some of the problems that we're talking. You got the cell tower in the middle. People don't like to walk a long distance. There's a lot of distance between the two buildings. If the parking for building 1 is where building 2 is now, that is a long way to walk in July heat in Charleston, South Carolina, or in the pouring rain, or somebody who's handicapped, or maybe just elderly. They don't qualify as handicapped, but the elderly, they got to walk way over there. So keeping the parking arrangement the same makes a lot of logical sense. There's not going to be a lot of people pouring through this private lane out of 4 homes. I don't think it's going to be. It's been a very successful parking arrangement for 60 years. I don't think it's going to be a bad parking arrangement if we continue it. So that's how I mean, if we made the buildings, each 1,000 square feet, could we park more cars closer to the two buildings? And that gets to the purpose of these criteria. I've got a very unique situation that I didn't cause. I didn't cause a 100-year-old lane to be there. I didn't cause a 60-year-old building to be there. That's because the property is so unique and the situation is so extraordinary that we have this issue. So I don't think removing one of the buildings is really going to solve the parking issue. I would still want to be able to park on both sides of the lane if I just had one building, just so ADA and elderly would have a close, and people in the heat would have a close way to get to the office building.
Mr. Duggan, let me start with my board members and let them start asking you some questions now, because typically we have a 2 or 3 minute time limit on this part. The first question that I would ask, actually, it just escaped my mind. I just drew a blank. It's getting late. All right, so I'm going to defer to somebody else. Y'all have questions for Mr. Duggan?
I just have
All
the
right.
one.
Mr. Neal?
Yeah, you're saying that you didn't create this problem because that access easement's been there for 100 years, but you are creating the problem, the way I look at it, because you're bringing more traffic there. You're bringing the office traffic, which is now going to impact the access easement to the rear property because of all the people that are going to the office building. So that's kind of how I'm looking at it, is although you don't think the impact easement's going to be affected because there's only 4 homes back there, well, those 4 homes are going to be affected, and that's one of the biggest criteria, is that we don't want to upset the community or change the surroundings for the community. So I just think you're putting too much stuff in this area that's going to impact it. And I don't know the layout of where the people are gonna have to go and walk if you were to reduce it. I think it's all being driven by the amount of office space, and it's just too much in there. And you're creating that, and that's why we couldn't get past that criteria. So if you tell me another way that you can do it and come up with it, I'd love to support it. I know the property very well, but it just seems like the same issue keeps coming back, and it's scaled down. I applaud from the last plan, but it's still the same issue.
Right, and you know, at the last meeting, we had about 20 neighbors complaining, and they were actually complaining because they misunderstood the project, and they thought these buffers were being requested on the south side of the property. And I met with all of these people and explained that, and that's why we have no opposition, zero
No
opposition
letters of
from the
support
neighbors.
here either.
Pardon?
You have no letters of support from them.
There are letters of support in my earlier application. I probably through oversight, I didn't, maybe not repeated them in the second one. But, you know, I did, the neighbors on the south side, different group of neighbors. It's one of the miscommunications that happened. Some of the neighbors on the south were in support of the project. That was part of the miscommunication last time. And I think, you know, is it semantics? I don't know. When you have the right to develop your property and you're putting up a building, are you causing problems when you put up a building that you know, zoning allows you to put? You know, it's a big piece of property. It's 2 acres. There's this huge chunk of land back there, and it just seems like it does meet the criteria for a variance of this nature.
It's just got a cell tower on it, and like I said, they're not saying they can't develop it. It's just how much of it can you put on it? And that's the issue I have. That's just me.
Okay.
Thank you.
Mr. Duggan, I think in the previous application, you had a letter of support from the Royals next door indicating they didn't have issue with this application, and it's their common property line this would abut, correct?
Correct. There was not a letter from them. I met with them, and they had no problem.
All right. So it's your testimony that...
It's my testimony.
All right. And in regards to the way this current access is set up, and you know, I look at this, I don't share the same concerns as my fellow board members. And in particular, I think about an access point like this, and I think to a very common situation regarding the number of apartment units that exist in this town that have parking exactly like this strewn throughout the entire complex, and a lot less or a lot more traffic than just would be generated by 4 residents on the backside of your particular piece of property. And owing to the fact that there's actually no way to do any development back there without some sort of variance being issued, speaks volumes to criteria number 6 in my mind, that the applicant meets this particular requirement just simply because there's no way to develop anything back there. I mean, have you explored how you could develop the property with not even needing a variance?
It's, Kyle and I have run numbers. It's virtually impossible. It would be impossible because you have to eliminate the front parking.
Which eliminates the business use.
I literally said, Kyle, figure out how we can do this without needing a variance. He said it is impossible.
Right.
And
are there any other questions for the owner of the property or the owner's representative? All right, thank you, Mr. Duggan, for your time.
Thank you.
Is there anyone else here to speak in favor of this request? Is there anyone else here to speak in opposition? I'm thinking not. All right. Do we have any questions for staff before we call for a motion? No questions for staff. Oh, we got a question.
Is there a way where, I mean, if they don't develop this property, the back house, the front's going to stay the way it is with the parking. So is there a way that we could make an approval that would not modify the parking on the front parcel?
Yeah, you could just approve the parking, the existing parking. A variance for the existing parking.
What was, I didn't quite track on that.
I think he was asking if we can approve a variance for just the existing parking versus like the proposed, yeah.
Okay.
Is that correct? Did I answer?
Well,
that?
I'm asking.
But if nothing is proposed in the back, no, we don't even need to be here tonight. Isn't that correct?
No. When they have applied to add these additional buildings, it triggers the full site plan review, which requires compliance for the whole property.
Yeah.
Right.
So the parking by the front building is not compliant.
Right.
So, you know, so there could be an option to like, hey, oh yeah, well, we'll give you pass for the stuff that was existing, but everything new would have to comply
all
with
driven by the
the
office
current ordinance
buildings.
or something. Yeah, like they, yeah.
The development of the backside is triggering the front side.
I get that.
Yeah,
Yeah.
so there's no way around, unless they came back with something that was a smaller scale that doesn't drive as much parking, then you'd see different amount of variances, but.
So all we're essentially doing in that case is denying this request as well.
Right.
We're not approving
Right, right,
anything.
Right,
Yeah.
yeah, so that doesn't solve it, so, I'm probably in the minority, I'm fine.
All right. Can I get a motion regarding this application? If not, the chair will make a motion. I mean, we can move this along. In the matter of case number BZA 0425000861, I would make a motion that we approve this request. In making this motion, I find that we meet all 7 of the criterion, I think it's 7. Yep, 7 of the criterion required to grant the variance request. That 1, there are extraordinary and exceptional conditions pertaining to this particular piece of property. I believe the applicant has done a very good job of explaining the current status of the property, the location of the existing easement, and I am compelled by the fact that it's been there for in excess of whatever, 50 years, 100 years, that is what's driving the need for this variance as much as anything else. That 2, these conditions do not generally apply to other properties in the vicinity. As the applicant has stated, the existing access easement and existing parking and drive aisle and existing cell tower and overall site constraints and boundary available are unique to this property and is what is causing the site constraint. So we meet that request. That 3, because of these conditions, the application of the ordinance to this particular property would effectively prohibit or unreasonably restrict the utilization of the property. Again, as we could get down into the nuances of how moving various pieces of the project around would not lessen the amount of variance that we might need to issue or lessen the amount of parking, but there's no way for that back half of the property that I can see to do really anything back there without some form of a variance. So I do believe that the application of this ordinance would effectively prohibit or unreasonably restrict the utilization of the property. That 4, the authorization of the variance will not be a substantial detriment to the adjacent property or to the public good, and the character of the zoning district will not be harmed by the granting of this variance. I think this is partially evidenced by the lack of outcry that we've had this time around, and is probably evidence of the amount of time the applicant has spent working on this project, working through various iterations of the project, and working with the neighbors to make sure that concerns have been removed or at least lessened. That criterion 5, the BZA shall not grant a variance the effect of which would be to allow an establishment of use not otherwise permitted in a zoning district. We clearly meet that criterion. For criterion 6, the need for the variance is not the result of the applicant's own action. Again, in looking at various ways to develop the rear portion of this property, there is no way to establish any form of parking without encroaching upon the roadway easement that's required by the county. And so to meet these parking requirements for the buildings, I do not believe that it is the result of the applicant's own actions. And for criterion 7, that granting of this variance does not substantially conflict with the comprehensive plan or the purposes of this ordinance. I believe we meet that criterion as well. We are consistent with Zeldar. In making this motion, I would include the 2 special conditions recommended by staff. I would say that is my motion, Mr. Chair, but I would be talking to myself. Mr. Seidel, we got a motion from Mr. Seidel, or a motion from Mr. Nelson, a second by Mr. Seidel. Is there any discussion? All right, we shall move to vote. All those in favor of this motion, please raise your right hand and say aye. Aye. Any opposed? We have one opposed. The motion carries. Congratulations, your application has been approved. You'll receive the final decision from staff within 10 business days via certified mail. Please contact them for the next steps in the process. Thank you.
We should adopt this 8 o'clock rule.
Yes,
Ms.
so
Working,
next
any other
month,
business?
we're meeting on July 7th. And we have 6 cases. We can meet at 5 unless you guys really want to meet at 4.
Also, I lied to you. I will be here that day.
Oh, you, okay.
I will.
Okay.
I have my dates mixed up.
Okay. Would you guys want to keep the normal time at 5?
I missed how many cases you said.
6.
6.
I like,
No appeals.
I like 4.
No appeals.
I don't mind doing 4. If everybody can make it at 4, I'd say
Everyone
we
agree
keep
with
doing
4?
4.
Can't make it, we might have enough to start.
Okay, that's
I mean,
fine.
that's one of the longest days of the year, and get home in time to go fishing. I'm all for it.
Okay, 4 o'clock it is. And of course, the training, you know.
Training, don't
Training,
forget to get
training.
trained. All right,
We'll get everyone trained.
this meeting is adjourned. Thank you.
We get overtime pay?
Yes.